even when it is difficult, the patience to listen, even in disagreement, and the humility to accept that we are but instruments of your greater will. May this new criminal code become a beacon of fairness, accountability, and hope, reflecting not only the rule of law, but the heart of a just and compassionate nation. All these we ask in your holy name. Amen.
Thank you. Thank you, Congressman. We would like to we would also like to recognize the members of the House of Representatives who are present at today's TWG, and that would be Representative Roman Romulo of the Lone District of Pasig. Sir, thank you very much for making time for this. We'd also like to thank our resource persons. Thank you so much for making time for this, and I'm terribly sorry for the delay in today's proceedings. We'd also like to ask our committee secretary to recognize our resource persons present.
Thank you, Madam Chair. For today's meeting, we have the following resource persons from the Department of Justice. We have Regional Prosecutor Greme June Elmido. Morning. Regional Prosecutor Janet Grace Fabrero. Senior State Counsel Berlin S.M. Burba. Morning. Deputy Regional Prosecutor Raul Cristoria. Assistant Regional Prosecutor Marines Ledesma Ciudadano. Morning. City Prosecutor Sheila Mar Saliganan Abadia. Morning. City Prosecutor Lisa Jorda. Oh no, I'm sorry. Then we have Senior Assistant City Prosecutor Rudy Camora Jr.
Good morning, Your Honors.
From the United Nations Office on Drugs and Crime, we have Dr. Nick Tobia and Ms. Sofia Offerman. Good morning. From the University of the Philippines Law Center, we have Professor Dan Calica, Professor Neil Anthony Borja, Attorney Linda Malenab Hornilia, Attorney Fines Estigoy. From the Legal Education Board, we have Attorney Mark Benedict Sampaga and Ms. Danica Tantay. From the Public Attorney's Office, we have Attorney Noliver F. Barrido and Attorney Angela Hernandez. From Ateneo Law School, we have Attorney Harvey Bilang. From the Office of the Solicitor General, we have Attorney Maria Vanessa Marayan. That would be all, Madam Chair. Thank you.
Thank you, ComSec. Thank you, ComSec. Quick recap on what transpired the last TWG. So we tackled a number of things. First, on the general principles of penal laws under Articles 21 to 23, we affirmed the retroactive application of favorable penal laws with continued debate on excluding habitual delinquents. We adopted the pro reo principle in concerning the liberal interpretation in favor of the accused. Rather, that was the underlying theme also under the general principles discussion. We also had we had discussions as well on preventive imprisonment, and these included first the crediting of detention periods towards sentences. Second, distinguishing police custody versus jail detention. Third, the treatment of hospital confinement. There was no final resolution on these sub-matters, and we still encourage further study and vetting and weighing in also on these topics. Second, we also discussed the penalties framework under Articles 24 to 27. And in that discussion, we introduced community service as principal penalty. We retained traditional penalty nomenclature with possible clarifications. We agreed to include penalties for juridical entities such as fines, closure, asset forfeiture. And we debated accessory penalties, balancing first the automatic imposition versus judicial discretion. Second, deterrence versus fairness and rehabilitation. And third, we also maintain that accessory penalties may need to be exposed but will have to be subject to further refinement. We also discussed the difference between reclusion perpetua and life imprisonment. We had an extensive discussion on harmonizing or distinguishing the two, and the consensus was that first, that both are effectively subject to a maximum 40-year service cap. Second, that reclusion perpetua remains an indivisible penalty. And third, we propose to formally define life imprisonment in the code, or whether we will define rather life imprisonment in the code is a matter that remains for further study. Fourth, we also discussed victims' rights and policy considerations. So we highlighted the need to balance the rights of the accused and the victims. We noted the concerns raised on the lack of victim notification. For example, early release through GCTA. We recognized also that certainty of punishment and not severity is what drives deterrence. Fifth, we also tackled comparative and reform approaches. We considered adopting aspects of the Spanish penal system, including structured penalty ranges from minimum, medium, and maximum, income-based fines, and we agreed in principle to explore these reforms while maintaining local legal consistency. Sixth, we had technical revisions and structural changes also with respect to reorganized provisions. For example, pardon was transferred to extinction of liability. And then we deleted redundant provisions and clarified rules on complex crimes and quasi-offenses. And then lastly, we improved the structure for pecuniary liability. So that's for restitution, reparation, and indemnification. And the overall direction of the committee is still towards working towards a modern and comprehensive criminal code that harmonizes existing laws and jurisprudence, incorporates international standards, enhances clarity, fairness, and enforceability, balances deterrence, rehabilitation, and victims' rights. And so with the deliberations that are going to continue, we will continue to focus on preventive suspension and crediting of detention, accessory penalties and judicial discretion, and final structure of major penalties, including reclusion perpetua and life imprisonment. So now we will resume discussion. We will begin today's discussions with Article 48 rather. Thank you. Does anybody have anything to contribute on, or are there any comments on Article 48? Attorney Angela? Ma'am, yes, Pao.
Good morning, Chair. We wish to backtrack for a while on a previous discussion regarding well, it was not discussed during the prior hearing regarding subsidiary penalty. Our initial comment is that well, the draft in our matrix for the leftmost part for the revised penal code is, I think, the old provision. It was already repealed by RA 10159. Nevertheless, our comment is regarding the new provision, the revision that we are introducing the community service mode of rendering subsidiary penalty. Firstly, if based on the previous rule, if the offender committed a grave crime, he is not subjected to subsidiary penalty. Based on paragraph 3 of the revised Article 39, which reads that when the principal penalty imposed is higher than prison correctional, no subsidiary imprisonment shall be imposed upon the culprit. So now we are requiring them to render community service. So that's a substantial difference. And also, for community service in general, our concern is there's no clarification or exception. What if the accused cannot render service, like they are senior citizens, disabled? Perhaps we can clarify this in the text of the law itself so that those who will need to prepare IRRs shall already be properly guided. That's all po. Thank you.
Thank you very much, ma'am. May we hear from the DOJ with respect to the imposition of community service and also the reasons for its noting also the points that were raised by Pao. Yes, ma'am. Attorney Abadia.
Thank you, Madam Chair. We would like to clarify from the good lawyer whether or not they are not amenable to the fact that when it's a grave crime, the accused cannot render, whether or not, yeah, do they not want to impose subsidiary penalty when it's a grave crime?
Ma'am, maybe hear from Pao. Are we doctrinally opposed to the imposition of subsidiary penalty?
We just hope to ascertain the wisdom of making those who are punished with grave crimes liable for community service. Of course, if we require them to render community service when the old provision technically, they're not exempted because in the 5th paragraph of of Article 39, as revised by RA 10159, it would read that if they are not a subsidiary personal liability which a convict may have suffered by reason of his insolvency shall not relieve him from fine in case his financial circumstances should improve. But if the principal penalty is prison mayor, previously they are not liable for subsidiary penalty, correct? Am I correct? Wala.
Yes, ma'am.
I believe that the wisdom for this provision is that in the field, even if there is a penalty of fine imposed on accused convicted of grave crimes, they are not able to pay the penalty, the fine, because for one reason or another, either they don't have any properties or they keep their properties away from the victim. So I think this is equitable in the sense that if they cannot pay the fine, then at least there will be subsidiary penalty for the fine that shall be imposed on them, even if it's a grave crime.
Thank you, ma'am. Ma'am, does that satisfy the concerns raised by Pao?
It's just our concern since this is this imposes another burden for the accused. We will have to reserve our agreement to include this provision to the revision.
Okay. Thank you very much.
Thank
Your
you.
Honor,
Yes, sir.
insofar as burden, I think that is part of his the penalty. So he has to satisfy the penalty. Thank you.
Thank you. Thank you, sir. Yes, ma'am.
But yun nga po, because the previous provision, with the previous provision, wala sila. And with the new one, meron silang another thing to accomplish. So it's more tedious for the accused. It's not beneficial for them. So that's where our reservation rests. But
Yun,
yun lang.
Your Honor.
Thank you.
May we know if our colleague here wants to repeal the existing, the old law now or the existing law that she is referring to cover, including those penalties above correctional?
Yes, yes, grave crime. Yes,
Yes.
yes.
Is that
What?
what you mean, ma'am?
No naman. Just in case, just if our revision is more tedious for the accused, that's where our reservation is. Because based on the on paragraph 3, when the principal penalty imposed is higher than prison correctional, no subsidiary imprisonment shall be imposed upon the culprit. But with our new revised provision for Article 38, it says that those who if the convict has no property with which to pay the penalty of fine classified as grave crime, he or she shall render community service, whether any period render community service of not less than 4 months and 1 day, but not more than 6 months. So yun nga po, from they will declare that they have no properties, then they will not render any form of subsidiary imprisonment. Now, with our revision, there is another thing that they will be required to do if they don't have any property. That's yung difference lang na yun. Yes, we added an alternative. So that's our reservation.
Thank you.
It's like we're adding a penalty for that specific instance.
Thank you. Thank you, ma'am. May we recognize Kong Roman?
Madam Chair, maybe we can get guidance from the experts, all experts here. In the current law or past law, in the RPC, bakit hindi sinama, bakit walang subsidiary liability kung more than prison correctional? Because if we find out there's a reason for that, then maybe because of that reason, we can decide if community service is also acceptable or not. So is there anyone here who would be able to guide the technical working group on the reason why until prison correctional lang?
Thank you. Yes, Professor Dan.
Yes, Madam Chair, good morning, Congressman Romulo. The previous subsidiary penalty consists of imprisonment po. So, since a person who commits a fictive penalty before, or more than 6 years, it would be an additional burden to impose additional imprisonment on that person. So, it's just limited to not more than 6 years before. But as worded now, I think this is very beneficial to the accused who's convicted later. And it also does not relieve the person who is convicted of a grave crime and he or she is not able to pay the fine because in the judgments of the court, it will consist of imprisonment and then it may also include fine. Okay. Now, there's no additional burden of imprisonment on a person convicted of a grave crime because this will now be substituted with community service. And I think the convict of a grave crime is very beneficial. It's just a community service of not exceeding 6 months, no? 4 months, 1 month, but not more than 6 months. I think the person convicted of a grave crime would be quite happy with this substitute for payment of the fine. I think although the proposal for community service is it should not exceed 6 months in the current draft. And if I may also propose, Your Honors, Madam Chair, it removes that last paragraph wherein if a person has served the subsidiary penalty, if the financial condition of the person improves he or she is still required to pay the fine. And based on the current wording, I understand it, this person will not anymore pay the fine. No, I just want to clarify that this person fully satisfies already the fine if he or she serves the community service provided in Article 38. So that's quite unfair in the present wording in Article 39. Aside from serving the additional imprisonment, he or she will still pay the fine if his or her financial condition improves. No?
Madam Chair, just to again ask Professor Kalika or anyone, in the it was thought to be unfair because may maximum prison time na dadagdagan mo pa yon. That's it, di ba? So because may maximum prison time na, we don't want to the framers of the RPC probably thought ito sobra na yan kung babibigyan mo pa dahil does it violate any constitutional provision about non-payment of any yun yung point ko, baka mamaya may ganun. But more importantly than that, pag imprisonment kasi it's deprivation of liberty. By community service, is that not also deprivation of liberty? So the extension of the commutation of not payment of fine that you're going to apply na community service ka, is that not also deprivation of liberty? That would, of course, it's a policy decision right now, but we can get guidance from the framers of the 32 siguro, 1932 RPC or the Spanish Code, whatever, para malaman natin kasi I think that was the point earlier that baka naman hindi natin tinitingnan yung reasons behind it. At mag-i-impose tayo ng community service. Effectively, deprivation of liberty yun eh. Kasi kailangan siyang mag-community service for 6 months eh. Is that not violative? Again, just for guidance. I'm not saying na, I know, again, I don't know also the answer, but I'm just saying, there must have been a reason why pag prison correctional above hindi na, or beyond prison correctional, and it's probably because we don't want additional imprisonment for non-payment of whatever, di ba? That's for sure. So, ang question ngayon, pagpapalit ba natin, pag-impose ng community service, is that not equivalent to deprivation of liberty also? So, ma-extend mo rin. So, just to be fair, I mean, at the end of the day, we all agree the last time we were here, hindi naman yung length of time eh. Di ba? Yung importante because yung reform ang importante at magkaka-reform man before that. So, just for guidance. Baka naman, it is burdensome again. Yun ang pananaw ko. But again, guidance lang from everyone.
Thank you.
Madam Chair.
Yes, Professor Dan.
Congressman Rom, actually, one possible objection to community services, it constitutes involuntary servitude po. And in the Spanish, in the current law, RPC, it's just considered as an alternative to arresto mayor or arresto minor, which are deprivation of liberty. And it's a choice of the convict whether he or she will apply for community service. That means that he or she consents to the servitude. So, to answer your query, whether this also consists of deprivation of liberty, no, but it constitutes servitude on the part of the person convicted. And I think it would be more beneficial to the person to serve community service. In fact, this is what is being done in NSTV now for our colleagues.
Professor
students.
Dan, the penalties you mentioned are light penalties, meaning hindi naman kinakabahan yung state na mag-community service sila kasi yung penalty effectively light rin yung maybe it is punishable but not as grave as those punishable by reclusion perpetua. That's why papayagan natin sila mag-community service. But then when it comes to grave offenses, tapos papayagan mo sila mag-community service, again, may additional risk involved. So again, I will not belabor the point. We can move on to the next. But I think it was a valid point brought up by Attorney Hernandez. So maybe, Madam Chair, maybe all our experts can again think about it and give us something in writing what they really think. Because may reason bakit dati wala. And then now bilang i-impose natin a alternative penalty, and there are risks involved in doing that. And maybe this is going to be burdensome. But again, just I won't belabor the point, baka lang pwedeng pag-isipan lang, and then feel free to submit anything to the chair and to the DWG on what you on the fairness, and if you think it is something that can be imposed.
Thank you, Congressman. Yes, maybe, sir.
Your Honor, I think one of the reasons why that community service was enacted is during our past experience during the drug war. And it so happened na nagkaroon din ng pandemic. Punong-puno ang mga jails. So, ginawa ng gobyerno para nang sa ganun mapabilis yung paglaya ng mga iba na pwede nang palayain. Yun ang ginamit nila hong alternatibo para nang sa ganun. Meron kasi yung you are still incarcerated, you have served the penalty. The problem is that meron ka pa ring subsidiary penalty na binabayaran through imprisonment. So, isa ho yan sa mga pagbabago na tinignan nila para nang sa ganun, madeklag po yung mga jails natin ng mga panahon na yon. Thank you, Your Honor.
Pero sir, di ba, kung more than prison correctional, wala nga subsidiary penalty eh. That's the point. So, hindi mo siya pwedeng bigyan ng subsidiary penalty kung more than prison correctional. Maybe you are right. Pag prison correctional pababa, lighter offenses, tapos masyadong congested, talagang pwede mag-adjust. Yung question dito kanina that I understood from Attorney Hernandez was, if it is more than prison correctional, why are we imposing an additional burden? When under the current, wala nga silang burden dun eh. Yun yung point. Yun lang naman yung naintindihan kong point. Again, we can think about it and submit something. Again, sir, Madam Chair.
Thank you. Yes, sir. With the graver penalty, for example. But yes, yes, sir.
Thank you, Your Honorable Chairperson. Good morning, everyone. In this particular aspect of the discussion, I'm actually on board with the DOJ, and I see the wisdom behind it. To clarify, we're not veering away from the very nature of a grave felony just because the subsidiary, the attached fine will be substituted with community service. Isa-serve pa rin naman nung akusado yun eh, yung penalty nung imprisonment. Okay? And yung fine doon is not really like a form of a penalty which actually punishes, okay, the convict or the accused. It could be a form of compensation for the government because after all, these types of crimes are crimes committed against the state. So how do we compensate this in the event that the accused is financially incapable of doing so? We have to face reality that our jails in the Philippines, our prisons are so congested. And that is perhaps one of the reasons why the Community Service Act was enacted. We're trying to veer away from the classical theory of being so punitive. Baka pwede namang times are changing. Let's do something restorative for the accused. But it doesn't really veer away from the fact that the accused committed a crime that we're going to be punished for a penalty of more than 6 years. Doon lang po sa aspect ng fine. And then it also promotes restorative justice and decongestion of jail. That is my only opinion.
Again, Professor Borja, I'm not arguing that we should or we should not. The point is, the issue was brought up na currently under the RPC, wala siya pag more than prison correctional. And there must have been a reason bakit wala siya. And that is the reason why I'm saying that if we can hold on to not decide on a finality on it yet until we get the experts here give the experts here some time to think about it, because again, napakadali po mag-impose eh. Pero there must have been a reason why it was not imposed previously in the RPC. Let's not bypass yun lang akin ha, kasi laging may reasoning very we had a very thinking community naman talaga, society. So there must have been a reason bakit hindi nila inimpose beyond that. So again, just to give time to everybody to think about it, research a little, for us to find out bakit dati hindi. Kasi marami tayong mga batas ngayon na sa totoo lang, baka dapat yun na nga, din nga i-revise natin ulit eh. Pero again, thank you very much po. I don't want to, just want to give everyone the chance to guide the committee, the TWG. If you can submit something, that would be all the best. If not naman, and you really feel strongly for this, let the TWG decide on its policy. Yun lang akin. Thank you again. Thank you so much. Yeah.
Thank you, Congressman. Yes, ma'am.
Madam Chair, I remember in our early meetings with Yusek Vasquez, he mentioned that the current revised penal code was a translation in toto of the Spanish Civil Code. So to answer Congressman Romulo's question, we might have to go back to the transcript of the original 1932 revised penal code.
I said earlier, talaga naman, everyone who went through law school knows that, So, tingnan natin po yan, kasi even the Community Service Act that is being mentioned now, limits it rin eh. Doon sa minor offenses lang eh. So, there must have been a reason eh. Kung walang reason, wala akong problema, but let us just move forward with circumspect and make sure na hindi natin natatrample upon yung previous policies and reasons for that. Yun lang.
Thank you, Congressman. Yes. Now, if we can, yes, sir.
Good morning, Madam Chair. Still with the subsidiary penalty, as mentioned by my colleague a while ago, with respect to subsidiary penalty in general, if it's okay with the DOJ, may we suggest to add a sentence worded as follows. In case the convict cannot render community service by reason of age, physical disability, or other medical reasons, the implementing agency shall formulate and implement an alternative work arrangement which has the same effect as community service, subject to style, Madam Chair. Thank you.
Thank you, sir. We will, if it's acceptable to the DOJ, we will include that in our proposed revision for Article 38.
Madam Chair.
Yes, sir.
Good morning, Madam Chair. I support the proposal given by our colleague from PAO. It should be included. There's an alternative flexibility on the part of the government if the convict is not capable of doing this community service. Also, I think the suggestion of Professor Calica on the last paragraph of Article 30 under the present RPC 39 should also be included. I think this is a typo error. In case the financial condition of the convict improves, he should still pay the fine.
Thank you very much, sir. Professor Dan.
Madam Chair, on the contrary, my proposal is to clarify that once the person has served community service, he or she has fully satisfied the fine, because it's unfair. The last paragraph is quite unfair. That somewhat constitutes double jeopardy already, right? And may I just suggest that as a matter of not style but substance, since community service is servitude, that we include with consent of the convict, Madam Chair, so that it's clear that he or she actually agreed to the servitude. And with regard to the suggestion of the Honorable Powell, maybe that we can just redefine what community service is, because if we, which would allow those with physical disabilities to render community service, not necessarily improvement of public works. That's the common notion of community service. Probably there will be non-manual community service that can be included. But that's just my suggestion on that.
Thank you, Professor Dan. So, two things for Article 30. Yes, Professor Harvey.
Hi, good morning. Regarding the phrase with consent of the accused, I'm not really against it, but I would say it's not needed. For one, the constitutional prohibition against the against involuntary servitude has a constitutional exception, which is that it's for if it's for a service for a crime for which you've already been convicted by final judgment. So constitutionally, this is permissible already. Second, if we add with the consent of the accused, now you run into a problem with what if they don't consent? What now would be the subsidiary penalty imposed upon the person? We don't want to impose again the penalty of imprisonment, right? So now, how do you now go about that problem when you have that phrase with the consent of the accused? Thank you.
Thank you, Professor Harvey.
Madam
Yes,
Chair,
Professor Dan.
it's not a problem. The convict has to pay the fine. So it's an option on his or her part. Of course, the convict is insolvent, so he or she has no property to pay the fine. So necessarily, his or her liability for payment of the fine subsists if he or she will not render community service, and it shows his or her lack of enthusiasm to reform or rehabilitate himself or herself.
Thank you. Yes, Congressman.
Madam Chair, again, just for food for thought na nung lahat before they give the final. Again, sa current na law, merong subsidiary imprisonment kung hindi mo mababayaran yung fine mo. And that is not within the choice of the convict. Tama? Offender. He must or she must do that. That's correct. So yun lang, if we provide now an option, kung a-accept niya o hindi niya a-accept, then limbo tayo pag hindi niya in-accept. Tama po yun. Pero ang point lang, tama po si Professor Dan, di ibig sabihin. Pero paano nga kung insolvent talaga? Wala talaga eh. So nakadangle dun na meron siyang Yun lang yung, again, not for us to finalize now, but for the experts to think about, na baka hindi talaga pwedeng optional eh. O voluntary yun eh. That is why hindi siya pwede talaga sa more than prison correctional kasi baka may pa rin, may madadagdag, kahit pa paano may deprivation of liberty eh. And ayaw nga natin to go beyond the 30 or 40 years, kung i-require mo siya mandatory na magsisilbi pa siya ng community service, kahit pa paano deprivation. That is why siguro take a look at it as a whole, one picture talaga. Take a look at it. Kasi yun lang eh, pag optional, pag arresto minor, talaga in limbo lang, kawawa rin naman yung tao, parang hindi niya alam, okay na ba ako? Hindi, di ba?
Agree. Thank you, Chairman. So, can we revisit, from DOJ? Yes, sir.
Thank you, Madam Chair. I agree with the point of Professor Bilang. It's subsidiary penalty, but it's basically a penalty. So it's not supposed to be subject to the consent of the accused, Madam Chair. And with the proposal of our colleagues from the Public Attorney's Office regarding the alternatives, depending on the physical condition of the convict, I think we can just add the word suitable or appropriate to the person or to the under the circumstances to make the provision of the law more simpler. That is all, Madam Chair. Thank you.
Thank you. Thank you, sir. So we would like to solicit language or first on the definition of or what would constitute suitable community service, especially when the convict is unable to render it, even though he should because he doesn't have the wherewithal to pay the fine for crimes classified as grave and above. So if we could solicit the language and the scope of what would constitute community service, we'd be grateful for that. And then second, what is still left hanging is the issue of how this should be couched. This provision should be couched, which is also going to be subject to the previous legislative intent for excluding community service for crimes that are grave or worse. So perhaps we could revisit this at some point, and then or we could circle back to this unless there are other questions or comments for this, because we can park this for now and then proceed to tackle the other articles, like Article 48 onwards. No further comments. Yes.
Your Honor, insofar as the definition of what is suitable for purposes of compliance of the subsidiary penalty, maybe if we can already just direct the implementing agency to determine what is appropriate, because sometimes the court would just import the decree the service, but these people are usually referred to the barangay, and then they have programs to do it. Ganon po yung ginagawa. So, ang mas magagaling po, halimbawa, the probation officer, yung DSWD, sila pong nakakaalam kung ano yung mas maayos na ipapagawa dun sa tao. That will be all, Your Honor.
Thank you, sir. So perhaps, Comsec, we could solicit opinions also from the appropriate implementing agencies. Next, if there are no further comments, can we go to Article 48 on the penalty to be imposed upon the principals when the crime committed is different from that which was intended. So this is still under the section. Still under the section on application of penalties, rules for the application of penalties to persons criminally liable and for the graduation of the same. Yes, sir.
Thank you, Your Honor. I applaud the committee for its initiative to streamline Article 49 and to put it in its simplest form. What actually concerns me is the phrase in the first paragraph, the penalty shall be for the lesser crime in its maximum period. So what do we mean by lesser crime here? Are we pertaining to a less grave felony or a light felony? So to quell any confusion, because under Article 49 of the RPC, what actually is intended to apply here is if there are two crimes, okay, one that was committed and one that was intended, the lesser penalty between the two crimes, not the lesser crime, okay, the lesser penalty between the two shall be the one to be imposed. So if it's amenable to the honorable committee and honorable chairperson, may I suggest that, quote unquote, if the crime committed differs from that intended, the lesser penalty between the two shall be imposed in its maximum period. Thank you.
Thank you, sir. Thank you for that suggestion. Yes, maybe hear from DOJ. It's clear. Thank you very much. So, Comsec, let's reflect that in our new Article 48. Thank you very much. Professor Dan?
Yes, Madam Chair, if I understand Article 49 before, now Article 48 applies only to mistake in identity. So, And the title now, just a matter of style, Madam Chair, may confuse law students and lawyers because there are three possible mistakes which will happen. Mistake in the blow, mistake in identity, and praeter intention. The mistake in the blow and praeter intentionem are governed by different articles in the criminal code. So may I just for clarity, penalty to be imposed when it refers to mistaken identity, Madam Chair. Just a matter of style, Madam Chair.
Thank you, Professor Dan. If there are no objections, we will reflect that proposed revision as well, subject to style. Yes, Professor Harvey.
Thank you, Madam Chair. Sorry, Professor Dan. May we retain the heading right now? Because I personally think mistaken identity doesn't really capture the essence of what Article 48 is all about. In fact, the current heading is what captures it, because it doesn't just cover mistakes in identity, but when you do something, you intend to do something, you do acts in furtherance of that, and the outcome is different from what you intended. That's what Article 48. So it's not just mistaking the identity of the person being victimized by your acts. Thank you.
Thank you, Professor Harvey. Professor Dan?
Yes, let me explain. Mistake in the blow will result to a complex crime or two different crimes, Madam Chair. But it's also, the result is different from what was intended. Okay? So it's governed by the proposed Article 47 now. Okay? Now, if the result is graver than what was intended, it will result to praeter intentionem, the accused will be guilty of the resulting crime, but with the mitigating circumstance of he or she did not intend to commit so grave a wrong. So it's not really covered by the proposed Article 48 or the Article 49 before, and this was I would like to cite the ruling of the Supreme Court in its decided cases that Article 49 applies only to mistaken identity po.
Thank you, Professor Dan. Okay. From DOJ, would you like to weigh in? Otherwise, we will still stick first for now to the initial proposal to revise the description for Article 48 and also the proposed language suggested by Professor Borja. Next, Article 49. Penalty to impossible crime. Did anybody have anything to comment? Yes, Professor Dan.
We already agreed when we define impossible crime, Madam Chair, that we remove inadequate and use instead ineffectual. So here it still says are essentially inadequate. I suggest we remove this and insert instead that the means used is ineffectual, Madam Chair.
Thank you, Professor Dan. We'll make that correction. So we'll make those global revisions to the reference to inadequate and replace it with ineffectual. Any other proposed amendments or comments on Article 49? Yes, comment.
Just to be clarified, we're talking about the old Article 49? Yes. Yung old Article 49, ang sinasabi po ninyo sa amin, based on Supreme Court rulings, or it's another article? Kay Professor Dan.
Sorry, that was initially
Na
Article...
mistaken identity lang.
Yes, Article 49, the old Article 49.
The old Supreme Court decisions have said, yun lang ang application niya.
Sa mistaken identity, yes.
Mistaken identity
Yes,
lang.
wakoy.
So, assuming that
you wanted to play a prank on someone you know. So, binigyan mo na parang, ano lang po to, theoretical lang. Binigyan mo ng something para, sabihin natin gusto mo lang masira yung tiyan niya. Eh, nung ang binigay mong dose ay, that person passes away. So, should that not fall under this one? Or it falls under something else? Because that is exactly yung point natin dati. That is why mala in se and mala prohibita matters for purposes of the RPC. Whether or not there is a decision by the Supreme Court, that decision may not be wholly correct. Diba? I mean, everything is challengeable naman diba? But we're creating policy here. So yun lang yung akin, Madam Chair. Pasensya na para maintindihan ko lang. Kasi saan magpo-fall under naman kung ganoon?
Yes.
Professor Dan.
Sir, Madam
Yes,
Chair.
Professor
Yes,
Dan.
that will fall under reckless imprudence or simple imprudence, Congressman Romulo. Okay, if there's a prank, because the person is not really committing a crime. If it's a prank, it's just for fun, but because of imprudence or negligence, it resulted to injury on the victim. It will be either reckless imprudence or simple imprudence resulting to homicide. Thank you.
Thank you, Professor Dan. Yes, Professor Harvey.
To Congressman Romulo's point, I completely agree. For me personally, his hypothetical scenario is covered by 49. That's why I wanted to have that subheading be preserved, so to speak. And I would go a step further, where the problem with Supreme Court decisions is they even go a step further in saying that when someone dies, it's a conclusive presumption that there was intent to kill, which is actually wrong, because intention is, well, on the part of the malefactor. It's not really about the outcome. So this Article 49 is actually what you're talking about. To classify it as reckless imprudence is a bit inaccurate, because in reckless imprudence, you didn't intend. There was fault on your end, but there was no intent. That's the dividing line between reckless imprudence and intentional crimes or felonies before, right? So if you played a prank on someone, you intentionally did that. It's the outcome which you did not intend. So theoretically speaking, that cannot fall under reckless imprudence. Thank you.
Thank
Chair?
you. Yes,
Madam Chair, maybe, again, baka pwedeng pending lang. But Professor Calika, would it be unfair to retain the current wording na it can apply to, even knowing that may Supreme Court ruling saying na specific siya sa mistaken identity, but we all know, even the Supreme Court changes sometimes in decisions nila. So, would it be acceptable to you to retain it first as is, just in case mag-iba yung isip ng in the future na hindi lang mistaken identity, but it would cover the possibility na hindi naman siya reckless imprudence pero falls within 49. Unless, of course, tatingin nyo hindi na talaga mapapalitan yan. But maybe you can think about it and again advise the chairperson of the committee.
Thank
We
you.
will
Yes,
advise
Professor Dan.
the committee on these proposals for Congressman Ramon.
Thank you.
Thank you. Thank you. The DOJ want to weigh in, our prosecutors.
The DOJ would want to retain the wordings.
Thank you very
Madam Chair.
much.
Thank you.
Thank you. Thank you. So we will retain the heading of Article 48. And then subject to Professor Dan, yes, further advising us on how we should proceed. So we can revisit this. We can revisit this context a future time once we've gone over the rest of the discussions on penalties, and then it becomes clearer also. Thank you. So now we move to the article. We were also in Article 49. We received Professor Dan's comment on the wording for inadequate being replaced with ineffectual. Are there any other proposed revisions to Article 49? If there are none, we can jump to Article 50 on the rules for graduating penalties. That's in page 47 of the matrix. rightmost column. Are there other comments? If there are no comments for Article 50, we go to Article 51.
Madam Chair, sorry.
Yes, Professor Dan.
Yes. Of course, subject to the adoption of the House of the penalty of life imprisonment and then reclusion perpetua together. We're not quite certain, but as of now, reclusion perpetua is also an indivisible penalty under current legal regime. But we provided for a duration of 20 years and 1 day to 40 years. If it will be adopted later by the House, that reclusion perpetua will now be considered as a divisible penalty, then there will be no instance wherein there are two indivisible penalties which will occur. So subject to that deliberation and adoption later, Madam Chair, because here it still mentions two indivisible penalties. I'm just want to, for paragraph 2, it says when the penalty prescribed for the crime is composed of one or more divisible penalties. I don't know if this is just clerical. Before it states of one or two indivisible penalties and one or more divisible penalties. And that's still a possible what's this formula, Madam Chair, because it will still exist that there's one indivisible penalty and one divisible penalty to be imposed to their full extent. So maybe this is just a clerical or error, Madam Chair. May I just propose that we include one or more two indivisible penalties and one or more divisible penalties to be imposed to their full extent.
Thank you, Professor Dan. DOJ, yes.
Just a comment, Madam Chair. If we are going to apply the computation that I did last time, mawawala ito lahat. Yeah. Complications of this, applications of this sections, mawawala ito lahat. It will be more simpler.
Thank you. Thank you. Sir, another request also. If we could also, we'd be grateful if you could also flag the provisions that will disappear if we go with the scale that...
Yes po, we're PN Prosecutor Abadja and Prosecutor Cristoria, we are thinking of which of these articles will not be applicable if we adopt that kind of computation. Tapos, we're trying to collate everything and we're trying to put words into it.
Thank you very much. Thank you. Thank you. Yes, ma'am.
Madam Chair, it seems that this Article 50 is just the same as that provided for in the current Article 61 in relation to rules for graduating penalties. So it seems that it's just a typographical error, Madam Chair.
Thank you, ma'am. So we will make, for now, while we wait for the text of the new, of a reconciled computation, well, while we wait for the proposed text for recomputing penalties, we will first mirror Article 61 on the base draft, Article 50. So thank you very much for pointing out the clerical error, Professor Dan and Ma'am Sheila.
Madam Chair.
Yes, Professor
Another point, I'm just wondering, and of course we are discussing this in class. This graduation of penalties in Article 50 now contemplates that the divisible penalty consists of 3 periods. Now, there are also prescribed penalties where there are only 2 periods in the prescribed penalty for reckless imprudence, for example, resulting to less grave felony. And then the other one, if it results to reckless imprudence resulting to light felony, it prescribes only 1 period. Arresto mayor, I think, in its medium period. So what will be 1 degree lower if the prescribed penalty consists only of 2 periods, and if the prescribed penalty by law consists only of 1 period? My understanding is that supposedly paragraph 5 provides for application by analogy. Does that mean by analogy we lower the penalty also by 2 periods only? That comprises already 1 degree. And if the prescribed penalty consists only 1 period, we lower also by 1 period that consists of 1 degree already. Because the Article 50 contemplates there should be 3 periods. Just a clarification, maybe if we can include that in Article 50, or we agree that that's paragraph included in paragraph 5 already when we apply by analogy po. Thank you po, Madam
Thank you,
Chair.
Professor Dan. For now, let's include that what you mentioned, so that it's going to be, at least we already have that placeholder here. We'd be grateful for the proposed text. And then, of course, all of this is subject to the language, yes, the revised computation system. Next. For Section 2, rules for the application of penalties with regard to the mitigating and aggravating circumstances and habitual delinquency. So, Article 52. We started to tackle this before in light of the discussion on habitual delinquency. But if there are other comments also for the current Article 52 under House Bills 7142 and 7206, we'd be grateful. Yes, Professor Harvey.
Regarding Article 52, subparagraph 4, it says, the circumstances which consist in material execution of the act or in the means employed to accomplish it shall serve to aggravate or mitigate the liability of those persons only who had the knowledge of them at the time of the execution of the act. So, this, as per that, is correct, but in practice, what's happening is this is being overridden by the principle in conspiracy that the act of one is the act of all. So even if the other co-accused, co-conspirators are not really of the same evil mind as one of them, they all suffer the same consequences. They all suffer or impose upon them are the same aggravating circumstances. My question to the body is that the intention, or should we now clarify that it doesn't apply to conspiracy as well? Thank you.
Thank you, Professor Harvey. Would anyone want to weigh in? Anyone from our resource persons? So this is page 51, paragraph 4 of Article 52. Also, I'm mindful of the time. If ever, well, when the food is served, please feel free also to have your lunch. I actually have pastillas also from Carigara Leyte, which I will also pass around. This is one of our delicacies. Please help yourselves.
Thank
Sweet
you.
of Carabao's milk. Thank you.
Madam Chair,
Yes, sir.
thank you. The query of Professor Harvey, if this will apply to in cases where we are prosecuting accused on the theory of conspiracy, I do not think this would apply, Madam Chair, because in conspiracy, the participants supposedly agreed to commit the crime, and they in fact committed the crime. So there is already an agreement. All of them knew. That is why they fall under the theory of conspiracy. That is my opinion, Madam Chair. Thank you.
Thank you, sir. Yes, Professor Harvey. Professor Dan. Sorry. Professor Dan, did you want to add anything?
Yes, this article provides for appreciation of aggravating and mitigating circumstances of conspiracy is a different level altogether because it collectivizes criminal liability. I'm contemplating, for example, two persons agreed to commit the crime of robbery, killing a person, but only one of them actually used treachery in killing the person. So the conspiracy is on committing homicide, but as to the material execution of the commission of the crime, it's different. So it will be appreciated only against the person who had knowledge of the means, which is treachery. This is particular only to appreciation of aggravating or mitigating circumstances. In conspiracy robbery by a ban, there's conspiracy, and then if there's an additional assault to be committed, all of them will be presumed to commit also the additional assault because there's an original conspiracy. But as to the manner of committing the killing, it may be in the knowledge only of one of the four persons, so it will be appreciated only against a particular person. Just my thoughts, Madam Chair.
Thank you, Professor Dan. Professor Harvey?
Yeah, building upon that, just to give a concrete example. For example, if three people agreed to conspire to kill someone, their only agreement and understanding was they're going to kill someone. Clear that they're all guilty of homicide, as the case may be, or murder, as the case may be. But let's say in the execution of the act, one of them did acts that constitute the aggravating circumstance of cruelty. None of the other co-conspirators knew at the time of the execution of the act that this particular malefactor would actually employ those means. Under subparagraph 4, if that's going to be applied, that would only be an aggravating circumstance on the person who knew. Because subparagraph 4 says only with the person who has the knowledge at the time. So that's where the query comes from. Also stemming from, if you take a step back from subparagraph 3, when there are circumstances that are personal to the offender, it only applies to them, conspiracy or not. So just giving context as to where the query comes from. Thank you po.
Madam Chair.
Yes, sir.
I think the point of Professor Kalika is very enlightening. Indeed, it has been specified here. These are circumstances which consist in the material execution of the act. So I see the point of Professor Kalika. That is all, Madam Chair.
Thank you, sir. Maybe another quick question. Also to take the point raised by Professor Harvey further, if there's ignominy perpetrated, for example, like in the process of killing, and then somebody decided to dispose of the ashes, for example, a certain way, that's not going to pertain, I mean, that might be excluded from the conspiracy aspect of it. So will this find application in, for example, the disposition of the ashes in such a heartbreaking way? Hearing from recent reports, I'd be grateful also for that. If the DOJ could weigh in on that. Yes, sir.
Madam Chair, I get the point of Professor Harvey. Pero para sa mga piskal kasi, that is already a matter of defense on how you present your case. Yung sa amin, yung importante sa amin, the practical sense is that we prove, we lay evidence of the crime. Now, kung meron mang halimbawa, isa lang ang dapat papatawa ng bibigyan ng aggravating circumstances, that's their way of presenting their side. Defense na yun. Yung sa amin, yung kung ano yung krimen. If we try to include or incorporate in the code yung mga scenarios na inaano ni Professor Harvey, hahaba, mas magko-complicate yung interpretation ng code natin. We would want it more simpler, easier for the prosecution to lay out, and at the same time provide the defense counsels, the PAO, their scenarios in how to defend their clients. Parang ganun. So, yun lang po. Thank you po.
Thank you, sir. Professor Harvey.
Yeah, just seeking clarification also, only to explain it, because we need clarification as to what the law requires. I understand the predicament of prosecutors. It's hard to prosecute this because all the burden is on you. But I'm from the perspective not just of the defense, but rather of the judge. If I'm the judge that's going to apply the law on this case, what does the law require? In that scenario that I posed, if I am the judge in that case, do I segregate the aggravating circumstance among the co-conspirators or not? Yun lang naman po. Thank you.
Thank you, Professor Harvey. DOJ or PAO? Anybody who wants to weigh in on this? Yes, sir.
Precisely, yun yung trabaho ng judge na how to interpret it. He can, kung ako siguro ang huwes, I will look at the text, tapos you apply it to a case, then they will be the one to interpret it. I'm sure ang interpretation nila it will be equitable, hindi malayo sa text ng batas. Yun lang po. So if basically it's yung interpretation nila iba yung sa amin. Thank you po.
Thank you. Yes, Congressman.
Madam Chair, it is Article 52. Yes. So the current Article 52 and the proposed revision of 52, is there a big difference? Wala naman. So all that Attorney Harvey is asking us, just the intent. Yes, but as mentioned by our prosecutors, if we are just leave it at how it is being done currently, walang problema rin si Attorney Harvey. Yeah. So kasi in a way may sense di ba? Let the judge be the one to do that, di ba? So wala tayong problema actually as long as we don't declare any intention on our part. Is that correct? Okay.
Yes, Congressman. Thank you. So no other comments to because there were portions I think of Professor Dan, yes.
Yes, Madam Chair. Actually, for paragraph 6, 7, and 8, we included this in aggravating circumstances. This was the proposed enumeration of the special aggravating circumstances. So just a matter of style whether we will adopt here or in aggravating circumstances, Madam Chair. Now, with regard to habitual delinquency, just a discussion I would like to discuss, Madam Chair, and probably everyone can weigh in. We have several multiple offenders. We discuss recidivism and reiteration in aggravating circumstances. We included quasi-recidivism in aggravating circumstances also as the first two are generic aggravating circumstances. Quasi-recidivism is a special aggravating circumstance. Now, habitual delinquency is an extraordinary aggravating circumstance in the sense that for a habitual delinquent, one will be imposed two penalties. The penalty for the last crime and then an additional penalty depending on whether it's a third, fourth, or fifth conviction. But under the old, or in the RPC, habitual delinquencies was limited to 5 crimes: serious and less serious physical injuries, robbery, theft, estafa, and falsification, which are habitually committed by, supposedly, by individuals. But, of course, we now have also serial killers and serial rapists. So we're trying to redefine what habitual delinquency is. But I'm just concerned that, so for habitual delinquents, the proposal is he or she should have been convicted third time or oftener. Now for recidivists, it could also happen that one is convicted, commits and is convicted of murder, for example, a heinous crime. And then another murder, another heinous crime. Would that be graver crimes than if one is convicted of less grave crimes as provided in the definition of habitual delinquent? A quasi-recidivist may also commit two murders, Madam Chair. Both are heinous crimes. So I'm just trying to revisit these multiple offenders because a recidivist may also commit actually two very grave crimes, and a quasi-recidivist two very grave crimes also, Madam Chair. Yet, as we discussed earlier, they're not disqualified from the retroactive effect of penal law. But right now, for one to be disqualified, one has to be convicted 3 times of to be considered as a habitual delinquent, Madam Chair. So maybe we have to revisit if one commits and is convicted twice of murder or rape. These are very grave crimes. Would that person be disqualified already from the retroactive effect of penal law? My concern really is that they are not included in the definition of habitual delinquents as written now, Madam Chair. And I would like to reiterate the earlier suggestion that we remove less grave in the definition of habitual delinquents. And then we include also a clarification as written in Article 62 of the RPC that all these 3 crimes should be committed and the person should be convicted within 10 years from his last release or last conviction. Because I think that's the essence. This person committed these 3 crimes within a certain period, Madam Chair. Thank you po.
Thank you, Professor Dan. Does anybody want to weigh in? Yes, sir.
Thank you, Madam Chair. I'd like to course the question through you to Professor Dan also. No? I agree with his proposal to remove less grave penalties. And I don't I don't understand it directly, just at the moment, no. But maybe perhaps if I share an example of what we've seen in other jurisdictions, no, this could be helpful in understanding the effect of this on the criminal justice system. So around Southeast Asia, in visiting different prison systems, no, what we do know is that because there seems to be a change in discourse when it comes to drug offenses and drug use, of course, drug possession. These are the most common crimes all over Southeast Asia. What we've seen in some neighboring countries is that many offenders, they keep returning to prison like 15, 18 times, 20 times for the same offense of possession usually. No? I've seen this in Malaysia, I've seen this in Indonesia. No? And what I can see is that because this is a special law now, I'm still trying to see where it fits into the hierarchy of penalties now in the RPC. But what I think is important to point out here is that if the national policy is to reduce prison populations, it does not make sense to impose additional penalties for repeated offenses, especially for something as minor as possession of drugs. So I'd like to know if this would be beneficial. Maybe this is a good compromise, Madam Chair. If Professor Dan can address this, no, by removing less grave crimes or a certain duration is removed from this, so that we don't extend penalties, especially on offenses that may be a health issue more than a criminal justice issue, like drug use. Thank you, Madam Chair.
Thank you, Professor Dan.
Madam Chair, that's what I'm considering, because it may just be considered as a special aggravating circumstance instead of it's a specific species, no? This habitual delinquency, because there are two penalties imposed on a habitual delinquent. Do we still adhere to this effect for habitual delinquency with the change in the definition of habitual delinquent? Because I'm more concerned with the person committing and is convicted of grave crimes like murder, rape, terrorism. How do we deal with them? Do we allow them to apply for parole? Will they be allowed to, or will they be subject to retroactive application of penal laws, considering that they committed and are convicted of very grave crimes? No? That's what I'm more concerned in. Of course, I suggested the removal of less grave felonies, or crimes rather, because these crimes are just punishable by up to prison correctional, which is up to 6 years. The purpose of the law should be to provide these persons second chances to reform and rehabilitate themselves, Madam Chair.
Thank you, Professor Dan. Does DOJ have anything to add? If not, Professor Dr. Tobias, was that good? Thank you. If there are no further comments, yes, ma'am.
I would just also, thank you, Madam Chair. I would just also like to reiterate the point that we raised the last time, that when it comes to less grave felonies, yes, it carries a lesser penalty. However, what is being punished is the propensity of the crime to commit the same crimes over and over again. That would be all, Madam Chair.
Thank you. Thank you, ma'am. So, yes.
Here, so saan tayo doon? Because ang point ng iba, habitual delinquency is special. I mean, it's pero hindi naman ibig sabihin na kung paulit-ulit ka, ay hindi ka penalized, because under aggravating, you get the maximum for a new. So, we will wait for the so saan ba tayo nakatayo doon?
What is there a final from the board of experts? Ba tayo tatayo doon? Ano ba ang final? Or do they want more time to just submit to you, Madam Chair?
Because if the body is okay with adopting Professor Dan's proposal, for example, and then also considering that our jails need to be decongested, if we can just focus on the if we can agree to just remove the less grave penalties and focus on in determining what should be punishable by the propensity to commit, if we could just focus on the crimes with graver penalties.
We will submit to the discretion of this honorable body, Madam Chair.
Thank you. Thank you, ma'am.
And Madam Chair,
yes,
will
President.
as proposed, I think it will be good to submit discussion on multiple or repeat offenders. How should the law treat them? Because as I said, under the RPC, there are 4 multiple repeat offenders. But with the redefinition of habitual delinquent, it may affect our appreciation of how we treat these 4 multiple offenders. Or should we stick with the 4 multiple repeat offenders, or just limit them to just 2, or just 1 multiple repeat offender? They are treated similarly. So we will submit a proposal for that, Madam Chair.
Thank you. We'd be grateful for that, for the proposed language for that. Anyone else who wants to comment? Or do we leave this for now and then just move to the next article first? Anyway, these we can always circle back to this point later on. So Article 51 on the application of indivisible penalty. This is on page 53. If there are there comments on it? If there are none, we'll move to So, if there are no comments on Article 51 on the application of indivisible penalty, we move to, so Article 50, we initially tackled Article 52 before Article 51, because of the way it is placed in the, in reference to where it was in the old RPC. But if there are no comments on Article 51, we move to Article 53 on the rules for the application of penalties, which contain 3 periods. We'll just make the necessary revision style also.
Madam Chair?
Yes, sir.
Sorry to... we would like to raise some minor comment under Article 52 on habitual delinquency. I think it is typo error.
Okay.
Under paragraph A, upon third conviction, I think we deleted the word third.
Yes, we agreed to reinsert that up.
Okay. And under paragraph, subparagraph B, it should be, on the last part of the sentence should be minimum and medium periods. Instead of maximum and medium.
Thank you.
That's all. Thank you, Madam.
Thank you, sir. We will make that corresponding revision. Medium and minimum periods. Other proposed revisions, if there are none. No comments on Article 51. We move to Article 53 on... yes, sir. Yes, Professor Neil.
Thank you, Your Honor. I think Article 53 simply echoes the old law on 64, which is actually significant when it comes to the application of the indeterminate sentence law. I simply seek clarification on paragraph 5, which states that when there are 2 or more mitigating circumstances and no aggravating circumstances are present. With the clause, no aggravating circumstances are present, do we mean that, does this pertain to situations wherein there are no aggravating circumstances at all from the very beginning? Or do we also include offsetting? Meaning, there is an aggravating circumstance and then offset siya na mitigating. Kaya, wala nang aggravating circumstance because I believe that this was also, this is too academic. This was asking the previous bar exams. So medyo nahirapan yung mga, I think mga 2000, year 2000 ba yan? Oo. And I think it was suggested by the panel of experts back then that this only envisions situations wherein there is no aggravating circumstances at the very beginning. So to clarify, if we're going to assume the position on that respect, would it be apt to phrase it in this way? And no aggravating circumstance exists to offset them, and then comma. Unless the board or any esteemed members of this board would enlighten us if there's a different position. Thank you po.
Thank you. Thank you, Professor Neil. Would DOJ like to weigh in? Yes.
With the proposal.
Okay.
Thank you, Madam
Thank
Chair.
you very much. So we'll make that, we'll revise paragraph 5 accordingly to reflect that there are no aggravating circumstances to offset them. Yeah, this is paragraph 5. 4 is the same. With it's still there. Thank you. Thank you. Are there any other comments to Article 53?
Just to clarify
Congressman.
na lang, yung sinabi ni Professor Neil, ang sinabi niya, there was a question in one bar exam, and the board of experts decided that, ano yung final conclusion nila?
That the problem back then includes an aggravating circumstance. And I think 3, mitigating.
Yes.
So lumabas, nag-offset, so may 2 mitigating. So anong rule yung mag-apply? I think the intent of the examiner back then is for the examinees to apply this provision when in fact it is not really applicable. Parang ganun po yung
5 or 4? 4 and 5?
Just 5.
5 po, 5.
Because it doesn't apply kung meron aggravating
Circumstance at all.
Yes.
Parang it just so happened that there is no aggravating circumstance because of an offsetting that took place.
Okay. But the 4 still is valid?
Yes po.
Yes, alright.
Opo.
Thank you. Thank you. Thank you, Congressman. Thank you, Professor Neil. Are there other comments? If none, we move to Article 54 on page 58. And this is on the rule in cases where the penalty is not composed of 3 periods. Are there any comments on this? If there are, Professor, if there are none, we move to Article 55 on the imposition of crimes. Any comments on Article 55? We can always circle back to this if this needs to be contextualized further. Yes, Professor Harvey.
For the imposition of fines, just bringing up a suggestion that may seem radical at first, but since we're rethinking our penalties, is the body amenable to having a fine system that is not based on a fixed amount? What we have right now is the statutes set what the amount of the fines are, which seems fair at first, but you, in effect, create a 2-tiered system where those who are poor, who are unable, who are insolvent, has to face a difficulty complying with the penalty. They have to go through the now subsidiary imprisonment, in the current state of affairs po, so subsidiary imprisonment, but you have also those rich people who are just going to do the act, pay the fine because it's fine anyway. So are we amenable to having a fine system that is based on the wealth, the income of a person? I note in Article 55 that that's already part of the consideration. It says, the last part, more importantly to the wealth and to the means of the culprit. So if you want a fine system that really constitutes a deterrent, you want it to hurt. And 1,000 pesos doesn't hurt to someone who's a millionaire. So maybe we can move to a fine system that would reflect that. It's progressive. Perhaps, for example, a percentage of someone's gross income. Just throwing it to the body, we can figure out the details later on. Thank you.
Thank you, Professor Harvey. I would be grateful also if we could solicit language from the body, because this would at least address also the fairness also of the penalty that's meted out, and also considering that we're looking to fine juridical persons as well. So if we could solicit comments, we'd be grateful. Yes. Yes, sir. Yes, sir.
We want that also, Yes, Your Honor. The suggestion is ideal. Everybody wants that. The only problem is how the determination of the fairness being allowed to. If the good gentleman could give us on how to insert it, the terminologies or the wordings, then we will be very grateful to study and examine and to agree, if possible. Thank you.
Thank you, sir. Dr. Tobia?
Thank you, Madam Chair. I'd like to address the question through you to the DOJ, perhaps. I think one of the things that we've brought up in the second National Decongestion Summit last January, which convened the judiciary and the DOJ and the ILG, was the issue of fines itself, like the nature of fines. One thing that we know from our prison and jail system is that very few people actually are able to pay fines. Now, I know that subsidiary penalties has been addressed in the current draft, no? So hopefully this will not translate to longer like imprisonment or detention for PDLs, no? But I think we can ask a more fundamental question. If no one, or generally most people, are unable to pay fines, what are the fines for? Are we hoping that we created a system, a pecuniary system, where some money would go back to, let's say, the judicial system, penalizing certain behaviors, and then the state is able to recoup some of its expenses in carrying out criminal justice procedures? But in the end, we find that very, very few people actually pay the fines. So why do we have the system in the first place? And if this only caters to very wealthy people, as Attorney Professor Bilag had mentioned earlier, we know also from the figures generally in the jail and prison system, this is a micro minority within the PDL population. And whatever money we're able to pay through the fine system probably doesn't count for much when we're talking about comparing it to the total expense of the criminal justice system in prosecuting offenders. So I think the question doesn't really address the provision itself, like to edit it, but certainly it's worth comment and examination, maybe in a separate paper, Your Honor, where we can take a look at the need for the fine system and maybe coming up with a clearer purpose behind it. And we'd certainly like to hear from DOJ if they're able to, at this point, to shed some light on this. Thank you very much.
Thank you, Dr. Tavia. Yes, sir. Sir.
Thank you, Madam Chair. But I think the concern of Professor Bilang is already being addressed in this particular provision, Madam Chair. There is a particular directive here to the courts to pay, in imposing the fine, to pay specific attention to the wealth and the capability of the convict. That is a specific directive to the courts. And the fines to be imposed, again, it is provided in Article 55. It's supposed to be within the limits of the law. That is the guidance of the court. I think this particular provision of the DOJ is very sound. Thank you, Madam Chair.
Thank you, sir. Yes, Professor Harvey.
I'll just respond po to that. The guidance to the courts in that sense is limited because the ranges provided for are fixed. It's not based on someone's ability to pay, if it's going to hurt them, if it's going to have a deterrent effect on their actions. The proposal is coming from the idea of deterrence. If I am an actor, if this criminal law is, if I'm going to make that decision, rather, to whether to do it or not, if I am a millionaire, if the maximum penalty of that is imposed upon that is 5,000, 50,000, it's not going to have a deterrent effect on me. But if the wording of the guidance of the law is, for example, the penalty is 1% of someone's gross income, of that person's gross income, I'm going to make that calculation based on my own circumstances, not on the fixed amount of 50,000 pesos. That is barya to me. But to the other comment of the DOJ, yes, I can submit proposals on the exact wording. There are actually in various jurisdictions different ways already to operationalize this. Some peg it on gross income, others on day fines. So their fines provision are based on the fine is 8 days of salary of whatever occupation you're in. We can also do that. So I'll be submitting my proposed wording on that. Thank you.
Thank you, Professor Harvey. Yes, ma'am.
Madam Chair, I get the point of Professor Harvey, but we are talking about the imposition of fines already, how the court will impose it. The Congress has the authority to fix the fines in the first place. So when we go to Book 2, then there we can change whatever it is that's stated there in accordance with the desire of Professor Harvey, Madam Chair.
Thank you, ma'am. So I'd be grateful also for if our experts could weigh in also on the fine section of Book 2, especially where where certain crimes also pertain to offenses or crimes rather committed by juridical persons. Thank you. So if there are, we'd also be grateful for additional literature on how to on fines as on the concept of fines and how and also guidance from other jurisdictions that we can also thread into the discussion, especially for Book 2. If there are no other comments on Article 55, we can leave this for now and then revisit it later on when we have other language also that can be added. But for now, let's keep this as it is. For Article 56, are there any comments on penalty to be imposed when not all the requisites of exemption of the fourth circumstance of Article 11 are present? Article 11 pertains to justifying circumstances. Yes, justifying circumstances. um, if exempting circumstances. That's on page 9 of the matrix. So we're in Article 56 on the penalty to be imposed when not all the requisites of exemption of the fourth circumstance of Article 11 are present. And number 4 of Article 11 pertains to when a person who acts under the compulsion of an irresistible force or under the impulse of an uncontrollable fear of an equal or greater injury. So,
Madam Chair,
yes, Professor Dan?
this provision is an exact copy of with revisions based on our amendments. This actually applies to incomplete accident, exempting circumstance of accident. So I was about to suggest that we remove reference to number 4 of Article 11 and then specify it as the incomplete exempting circumstance of accident. So there's no need for reference, or unless we have already the final draft of the exempting circumstance, we can make reference to accident.
Thank you, Professor Dan. So we'll have that bracketed text for now, replacing number 4 of Article 11 with the incomplete exempting circumstance of accident. Any other comments to this? If there are none, we move to Article 57 on the penalty to be imposed upon a person under 18. So, if there are comments on this, this is on page 59 of the matrix, Article 57. Yes, Professor Neil.
Thank you, Your Honor. Perhaps we could also clarify that the offender here is a child in conflict with the law, apart from the age. That's one, to be consistent with RA 9344, instead of saying that the offender is a minor. And the next is, can we also include the phrase "and acted with discernment" for clarity? Thank you, Your Honor.
Thank you, Professor Neil. If DOJ is comfortable making those proposed revisions.
Yes, Madam Chair.
Thank you.
Thank you.
Thank you very much. So we'll include those proposed revisions to Article 57, reference to minor as a CICL, and then also the sorry, what was the and acted with discernment. Thank you. Next, Article 58. Penalty to be imposed when a crime committed is not wholly excusable. There's also reference to Articles 10 and 11. If there are no yes, Professor Dan.
First, we're talking of the privilege mitigating circumstances. The previous phraseology is that majority of the, not all conditions are present, but majority are present for it to be considered as a privilege mitigating circumstance. In contrast to incomplete justifying or exempting in mitigating circumstances, which is just considered as a ordinary mitigating circumstance. So if that's the intent, we can replace majority of the elements are present. Unless, of course, this will be beneficial to the as currently worded, it will be considered as a privilege mitigating regardless of the number of requisites present. because this lowers by 1 or 2 degrees, right?
Um, maybe hear from DOJ. Yes, sir.
The wording is yes, the current RPC used the phrase majority of all the conditions, and the present formulation is not all the conditions. But upon further review, we realized that there are certain exempting and justifying circumstances which has only 2 elements, so it's impossible to secure the majority. So we suggest that instead of majority, the word majority, we use the word not all the requisites are present. For example, the exempting circumstance, justifying circumstance of there are 2 instances in the exempting circumstance when there are only 2 elements involved. So if we require majority, we cannot, it does not apply because 2 out of 2 will be exempting or justifying. 1 out of 2 will be not all the majority.
Thank you very much, sir. Professor Dan, is it okay if we retain the language?
It's quite, of course, incomplete, right? Justifying and then it allows the court to lower by 1 or 2 degrees. That's quite generous on the part of the court to lower by 2 degrees. So I think there's a ruling that if there are even-numbered requisites like 2 in fulfillment of duty, if 1 is present, the Supreme Court has ruled that its majority of the elements are present, so it will be considered as a privilege mitigating circumstance. So can we just include such a statement that majority of the elements, and if there are only 2 or 4 requisites, the presence of 1 or 2 will constitute majority, right? 1 of 2 or 2 of 4 or majority would constitute privilege mitigating circumstance, if that would be acceptable, no?
Thank you, Professor Dan. Yes, Professor Harvey.
Thank you, Madam Chair. Subject, of course, to the thoughts of the body also, just supporting the wording not all instead of majority, because from the perspective of a judge, you have more flexibility to tailor fit the circumstances. When the law says majority, quote unquote majority, it kind of corrals you into a mathematical computation of are all the elements here, or are the majority of elements here, whereas if it's not all, it gives you a certain leeway to say that, oh, we can apply this a mitigating circumstance even though not all the requisites of a certain exempting or justifying circumstance is present. Thank you.
Thank you, Professor Harvey. Does anybody else have a comment? If not, yes, Professor Dan.
Just a comment on that. Precisely, we don't want the court to have that much discretion in imposing penalties, because that will be productive of corrupt practices, no? So if the rules are quite clear in the imposition of penalties, there should be clear-cut rules on how this should be imposed. So I think if there are 3 requisites, 1 is present, that will be considered as an ordinary mitigating circumstance, which results to the penalty being imposed in its minimum period. Now, this is quite crucial, this Article 58, because it lowers by 1 or 2 degrees. That's quite a big, huge discretion granted to the court. And so the rule should be quite clear when the court may lower by 1 or 2 degrees. And as currently worded, it's majority, but I understand there are instances wherein there are just 2 or 4 elements of justifying circumstance. We're not talking of a lot of rules here. Okay? There are just around 11 or 12 justifying exempting circumstances. So we can provide a definite rule on when it will lower by the 1 or 2 degrees po. That's just my suggestion, Madam Chair.
Thank you, Professor Dan. Yes, Professor Harvey.
Thank you, Madam Chair. I-bring up ko lang din po, it's a philosophical question for all of us. No, it's been brought up to our attention numerous times, but I guess we have to answer the question, why do we have this trust of the judicial system? The very idea of having or corralling judicial discretion is you don't want judges to exercise that much discretion. You don't want discretion. I guess the question to ask us is why? Like as a community, as a society, why do we distrust judges? The flip side of that kasi is, yes, giving judges discretion can be subject to abuse, as with anything. Anything can be subject to abuse. But also on the flip side, if you're going to assume good faith on the part of the judges, it's giving judges the power to tailor fit the punishment to the crime. We are creating boxes. When we legislate something, we create boxes. But not every scenario is going to fit those boxes. So, judicial discretion is necessary in order to ascertain what kind of punishment, what level of punishment we impose upon a particular evil person. Yun lang po. Thank you.
Thank you, Professor Harvey. Yes, Professor Dan.
Just like to put on record that I don't distrust the judges. No? The point of the suggestion is the law should be clear and unambiguous. Okay, which a penal law should be. Okay, so it should be very understandable not only to judges but to ordinary lay persons. That's just a purpose of the my proposal, Madam Chair.
Thank you very much, Professor Dan. Yes, we note that, and we're also happy to back you up on that. We understand also the need to and if we might go back to Article 58, if there is no opposition to further refining what we mean by majority, if we can also adopt Professor Dan's proposed revision of the phraseology on what constitutes majority. Yes, Professor Harvey.
Thank you, Madam Chair. Just to clarify also on the record, I'm not imputing negative motives on Professor Callica. That comes from a comparative analysis of jurisdictions. There are jurisdictions that allow wide discretion on the part of their judges because that's the kind of relationship that they have as an institution, not as individuals, but the relationship between legislatures and judges. We tend to corral the judicial discretion that our own judges exercise, perhaps because we don't have elected judges. They're not representative of the people, but I'm calling into question, do we want that as a society? Do we want that we're looking at you, judges, and you're only going to exercise this amount of discretion, when, from a criminal justice standpoint, they serve a really good role, which is to tailor-fit the punishment to the crime. Yun lamang po. Salamat.
Thank you. Professor Harvey, we would be grateful also if, in providing context, you could tell us, in those systems where there's greater leeway, or where the law provides greater leeway, if it's also connected to the fact, for example, that it's a common law system, and then ours, of course, is civil law. So those distinctions will matter also in the relationships of the institutions. Yes, ma'am.
To simmer the discussion, Madam Chair, I'd just like to reiterate the view of the DOJ that we want the words to be retained as it is, Madam Chair. Thank you.
Thank you, ma'am. So, but ma'am, even as the words are retained as it is, would the DOJ be perhaps consider also if the DOJ could also look into what Professor Dan proposed, if we were to look at those instances where there's reference to majority in jurisprudence. If that could, I mean, right now we have the phrase "not all the conditions be present," but if that phrase could, or if DOJ rather could consider looking into wording that might approximate the view also that we still need a majority of the conditions to be there, based on what the previous Article 69 provided for. But that's just a suggestion also. And we can also revisit this later on. But yes, sir.
Your Honor, pansin my companions here, they agree with the proposal of Professor Dan Calica.
Thank you very much, sir. So we'll make the necessary revisions for Article 58, and then come back to this at a later time if it's when it's necessary. Next, we go to Article 59 on the successive service of sentences. Are there any comments?
Madam Chair, may I be recognized?
Yes, Dr. Tavia.
Thank you, Madam Chair. On Article 59 on successive service of sentences, I think I have two suggestions here. The first one is rather straightforward. No, one of the revisions is to indicate that a jail officer shall observe the following rules, and we just like a clarification if they also intended this to be corrections officers in general, no, including prison officers. So if that's the case, then perhaps it would make more sense to indicate this is a corrections officer, so that we can cover the three different branches of the correction system, including the provincial jail system, if they're holding convicted individuals. The second point that I'd like to raise, and this is rather radical, and I'd only like to leave this to the plenary to consider. In civil law jurisdictions around the world, they take on multiple sentences in different ways now. But one thing that we've seen is that when there are multiple sentences, different crimes involved now, what courts tend to do is to lump them together into a single penalty. And the reason why I'd like to raise this now is from our observations on the practice in the correction system now, when we observe officers in how they make computations of sentences and how they calculate release dates now, it makes more sense to our corrections officers to simply add all the penalties, and then that's when that's how they make a calculation on kailan yung release date po ng isang PDL, no. And I think in many instances they're corrected for this. They're told that this is wrong, especially since the provisions of the RPC say it has to be successively served in imprisonment penalties. And even if you tell them that you shouldn't add all the penalties together, whether you're doing it adding all the minimum imposed penalties and then another computation for adding all the maximum imposed penalties. I think there's a little wisdom that we can draw from this also, no? That in practical terms, it's simply more efficient if it was just one penalty that they were looking at. And just to explain this point, no, imagine yourselves as corrections officers with the duty of being the paralegal. And if you need to compute, let's say, the release date of an individual who has 3 different penalties, imprisonment penalties, you will have to start with the first one from the date that the decision is final, and then apply the duration of the imprisonment penalty. And then you're confronted with the problem that this duration is never set, because every month you will have to compute the time allowances that apply. So you never really know what is the exact duration of that first sentence. And if you don't know when exactly this first sentence ends, then there's no certainty, at least at any point before you actually finish the first sentence, when the second sentence will start to kick in. And then you keep doing this until the third, the fourth. Again, imagine yourselves as a frontline paralegal corrections officer trying to make sense of this system. And then when you get to the end, trying to serve the last penalty, we also have to remember that no total, the aggregate of all penalties should go beyond 40 years. So now your corrections officer needs to make a calculation. Yes, wait, how long has this person been in here for? And then I have to make a deduction for the time allowances that they've accrued. The point being, long story short, is that serving successive sentences is a very complicated procedure at the jail and prison level. And I would suggest, not for any philosophical reasons, no, but very practical reasons, we should just probably consider coming up with an aggregated sentence. And the guidance that we can get from other jurisdictions, we can follow different templates now. But generally, it's good that we already have a provision, a cap of 40 years. We cannot exceed 40 years on any total number of sentences. And then in other jurisdictions, they take a look at the most severe sentence, and then there's an algorithm to add to that, considering the number of other penalties that have been imposed on an individual. We can certainly write a paper, a comment on this, Your Honor, to give guidance to the committee. Thank you very much.
Thank you very much, Dr. Tabia. Quick question. Since we do a lot of, AI is able to program many restraints anyway. If the computation part can be, well, first, if it's possible to just have AI do the computation, is there a system for it where you have the prompts, and then with the correct prompts, you limit already the amount, or we will actually be able to whittle it down to what the aggregated sentence would be, given all the AI prompts that will be fed into the system. And if that's possible, where is it being practiced, or would you know of jurisdictions that already do that?
Yes, Your Honor. To answer your question, definitely you can simply apply algorithmic formulas to this to make the computation. If it's an AI interface, it could be simply just a matter of putting in all the relevant details of the penalties involved in a certain case. No? And I think what really matters is that the legislature is able to lay out what is the formula for deciding on an aggregate penalty. And creating the apps for that, of course, will come later on. We should note, of course, that the DOJ has been working very hard on the NGIS, or National Justice Information System. So I suppose that in the future, if we do come up with a base formula coming from national legislation, that this could be incorporated into the NGIS, so that the manner of computing release dates on an aggregated sentence could be very straightforward and just done through an application. On your second point, Your Honor, if we're looking at other jurisdictions, I don't have it on hand right now, no, but definitely countries like Brazil, Japan, Germany, and probably even France. No, these are countries that have different for an aggregate penalty.
Comments, none. We'd be grateful also for guidance on, or maybe an update on if there is, if the system is already looking also at digitizing the computation of sentences. Because having having a data center process it might actually give us the certainty that's needed, or help judges get or give judges the tools that they need, and also help with the general general task of decongesting jails. Okay, if there are no other comments for Article 59,
Chair?
yes?
Madam Chair?
Yes?
Pao po.
Yes, ma'am.
Just an observation. If we change the word jail officer to corrections officer, of course, I believe we've discussed it before, that those who have been detained in PNP custodial centers, their service there will not be considered as service for their sentence. I'm not sure if I'm correct with that statement, but there, if we stay with corrections officer, then we're already putting a period on the possibility of, we're already concluding that the service in PNP custodial centers will not be counted. So can we consider rewording or making it temporary as of now, yung corrections officer na term, in the event that we consider during the discussion of this RPC revision that eventually will change it to a more general place of detention, like to include PNP custodial centers or those areas of detention. Thank you.
Thank you, ma'am. We're grateful that you pointed that
Your Honor,
out. Yes.
if I will propose,
Yes.
jail or correctional officers.
Okay. Thank you very much.
I think it will sanction everything, Your Honor. For lack of a better term. That's true.
Thank you very much. May we inquire with Pao if this would suffice?
Yes, as long as we broaden the scope of the service of sentence. Thank you po.
Yes, Dr. Tobia.
Maybe something even shorter, no? Custodial officer could be a solution, like for anyone who holds a person under custody, no? So this could certainly include the PNP. DOJ, of course, with due respect.
Thank you very much for that proposal. Yes, ma'am?
Madam Chair, maybe we will just retain the jail or corrections officer, Madam Chair. Because when you say custodial officer, it presupposes that when a person is invited in the police station for investigation purposes, they may be considered as already under custody, but that does not, it's not included, Madam Chair.
Thank you very much, ma'am. So for now, we will keep it to jail officer or corrections officer, and then subject to us circling back to this later on what will constitute service of sentence. Next, yes, Professor Neil.
Excuse me. Thank you, Your Honor. Still in Article 59 of the proposed bill on successive service of sentence, I think this is simply a replicate of the current RPC. I just want to shift our attention on second to the last paragraph of this provision, because I understand that this is what we call as the threefold rule, and the threefold rule actually involves a situation wherein the convict is about to or is serving 4 or at least 4 sentences, and there's a limitation to it, that it should not, no case exceed for 40 years. And if I'm also going to take a look at any provision of the RPC, I could not locate an authority which would demonstrate a convict who is sentenced to, let's say, two sentences of reclusion perpetua or 2 or 3 of reclusion perpetua or life imprisonment, because the same rule that the
with respect to situations wherein uh, less than 4 years yung sentence, pero pag lumagpas na ng 40, no choice. We just serve at the maximum of 40 years. Thank you po.
Thank you, Professor Neil. May we hear from DOJ if, or if we maybe ask if DOJ could weigh in on that, or if you would need more time, we could also revisit this. Okay, thank you. So we note that what you raised, and we will wait for DOJ also to weigh in on this at a later time. But we're grateful that you pointed that out. Next, are there any other comments for Article 59? If not, we'll move to Article 60. Article 60 is about the graduated scale, so that it was lifted from the previous Article 71 of the RPC. If there is a way to... yes, Professor Dan.
Just note, Madam Chair, last hearing we agreed, I think, to include life imprisonment as one of the penalties. Of course, the discussion is without prejudice to the definition later of life imprisonment, and what would be the extent of the life imprisonment. Would that really be imprisonment for life? So that trumps the rule in Article 59 that the maximum will be 40 years. But that's just for a note, Madam Chair, because we haven't yet discussed what is the nature and the extent of life imprisonment, Madam Chair. I think it impacts on several articles.
Thank you, Professor Dan. We're very grateful you pointed that out. We'd also be grateful for the rest of our experts to weigh in on the articles that are impacted by the possibility of imposing a defined life imprisonment separate from reclusion perpetua or as a penalty. So we note also that we will have to bracket the inclusion of life imprisonment in Article 60. Any other? We'd also like to inquire from our experts if you have proposed definitions on life imprisonment to share with the rest of the body. If there are none yet, well, we'd be grateful to receive them at a later date. Any other comments? If there are none, we move to Article 61 on the preference in the payment of the civil liabilities. If there are no comments to Article 61, we move to Article 62 on...
Madam Chair,
yes, Professor Dan.
Matter of style, maybe it can be transferred to civil liability.
Okay.
Madam Chair.
Thank you, Professor Dan. May we ask from inquire with DOJ if we can move this article to the section on civil liability. We'll deal if Okay, so we will tentatively move this to the section on civil liability. Next, we go to section 3 on the provisions common to the last two preceding sections. So we begin with Article 62 on the legal period of duration of divisible penalties. Are there comments on this? If there are no comments on this yet, we move to Article 63 on when the penalty is a complex one composed of 3 distinct penalties. If there are no comments on Article 63, Article 63 is in page 64 of the matrix. If there are no comments on this, we leave this for now, and then we move to Chapter 5 on execution and service of penalties. Article 64 on when and how a penalty is to be executed. Any comments on this? Article 64 is the counter reference for what is now what used to be Article 78 of the revised penal code. This is on page 67 of our matrix. If there are no comments yet, we can always go back to this later on. We move to Article 65 on prosecution of children in conflict with the law. And we'd like to solicit your comments on this, if there are any. Although I understand this was discussed in more exhaustively previously. If there are no further comments on Article 65 on the prosecution of children in conflict with the law, we go to the chapter on, or the title on the extinction of criminal liability. So we start with Article 66 on under Chapter 1 on total extinction of criminal liability. And Article 66 is how criminal liability is totally extinguished. If there are comments, yes? Yes, Professor Dan?
Yes, are we through with execution of penalties?
Yes. Oh, no, we can always go back to sections that, or articles rather, that you might want to comment on.
Yes.
Yes.
Thank you, Your Honor. Yes. We noticed that the provision on Article 88 of the revised penal code on arresto menor and Article 88A, I think this is an insertion on community service. They do not reflect on the proposed bills. So perhaps it would be up to revisit them because it may affect other provisions in the proposed bill. Thank you.
Thank you, Professor Neil. We'd like to ask the DOJ what the reasons for exclude. We note that article actually that many of the RPC penalties are not reflected in the draft bills, and we would like to ask the DOJ to weigh in on the context for this. For example, Destiero is not reflected either.
You know, may we know what provision of law is that?
This is Article 87 of the RPC, Destiero, Article 88, Arresto Menor, Article 88A, Community Service. These are located in pages 75 to 77 of our matrix. So, we do not have counterpart provisions for it under House Bills 4374, 5446, 7142, and 7206. So we were wondering if the DOJ could kindly elaborate on this. Sir, sorry, mute.
Madam Chair, with respect to Article 87 on Destiero, we propose or intend to delete that as a penalty. However, we realize under Article 247 of the RPC is still included there. So we will make the necessary amendment once we go to that article on the that under exceptional circumstance. On the arresto menor and community service, I think community service is under Republic Act 11368, I think. In connection with the discussion under Article 39 of the RPC subsidiary imprisonment under 33, we saw the apparent discrepancy because under the community service law, that is only applicable under arresto mayor and arresto menor penalties. And that is the maximum is 6 months. No. However, with respect to the subsidiary imprisonment under Article 33, it appears that it can be imposed, no, even if it is above the arresto mayor penalty. So we have to make the necessary rectification on that, Madam Chair. Thank you.
Thank you. Thank you, sir. I'd also like to inquire about why the wisdom for taking out this tiaro.
I think, Madam Chair, looking at that, there are several decisions of the Supreme Court which says that this tiaro is not really a penalty, but it's more of a to protect the accused, no, under death under exceptional circumstances under 247. So, and this is no longer, I think, applicable under the present times. The old system of this year of banishment is no longer applicable. So maybe some other, in the future we could come up with another system of putting a tracker on the person, but not now. Maybe in the future, Madam Chair.
Thank you. Thank you very much, sir. I also wondered, for those who are under house arrest, do we have trackers also on their person? For those serving sentences under house arrest here? Or
Madam Chair, presently we don't have that system yet. But in Spain, they apply that under the Código Penal of 1995.
Thank you very much.
Thank you.
And will we be making provision for that, the inclusion of a tracker in the event that we consider?
Madam Chair, maybe in the future, but in the meantime, the directive on us is just to the low-hanging fruit, just amend and modernize the RPC. Later on, the suggested amendments will follow. Thank you.
Thank you very much. Thank you, sir. So, yes, Professor Dan?
Yes, Madam. Of course, we probation and the indeterminate, we discussed this with USEC Raul last time, Madam Chair. It's not included in the RPC, and these are just quite a few provisions on the indeterminate sentence law and probation law, and that pertains to graduation of penalties for the indeterminate sentence and execution of penalties for the probation law. So probably maybe we can incorporate the special penal laws already in the criminal code because these are quite old special penal laws, 1933 for the ISL and 1978, but recently amended for the probation law. And I think these are important beneficial rules for the accused and the convict, Madam Chair. But of course, the indeterminate sentence law is subject to the deliberation of whether we should still have an indeterminate sentence or we should already have a determinate sentence or just a straight penalty, and then incorporate later on provisions wherein a person may still apply for parole, okay, after service of certain percentage of the straight penalty, Madam Chair. So I think these are important considerations for the accused and the potential convict, Madam Chair, which I suggest we should incorporate in the criminal code, Madam Chair.
Thank you, Professor Dan. May we inquire with DOJ if we could include those provisions on probation and ISL here in before we get to Title 4 and Professor Dan, if we were to introduce those provisions, where do you suggest we reinsert them as placeholders?
The indeterminate sentence is in the graduation or application of penalties, Madam Chair. So probably after Article 63. And then probation will be in execution and service of penalties, Madam Chair, probably after Article 64. And may I actually suggest, Madam Chair, we don't have a definition of what community service is. So I think we also include a definition of community service in this chapter on execution and service of penalties, Madam Chair. Of course, we have to amend the Article 88A now because community service there is just an alternative to arresto mayor or arresto menor. Now, based on our earlier agreement, we have considered community service as a criminal penalty already, Madam Chair. So I think we should define it, and that will take into consideration the concern of the PAO office that it should take into consideration other persons who are not able to perform public works.
Thank you very much, Professor
Thank
Dan. With DOJ's, if DOJ will be fine with it, can we include or mirror at least in the base draft or the substitute version the provisions on arresto menor and community service, subject to the refinements we will make as we go along? Yes, ma'am.
We are agreeable to that, Madam Chair.
Thank you very much. So we
Madam
will.
Chair?
Yes,
Minor
sir.
suggestion on our part, under Article 66 of the present draft, may we come up with letter A, how criminal liability is totally extinguished. Criminal liability is totally extinguished, letter A, natural persons. And after 1 to 6, we come up with letter B on juridical persons, so as
Yes.
to avoid confusion. And we will put the number 8 under 7 of paragraph A on probation. Successful completion of probation under paragraph Article 66, paragraph 8.
Thank you very much, sir. We'll reflect those proposed revisions. Thank you. So now we move on to, if there are no, yes, Professor Neil.
Thank you, Your Honor. Based on the enumerations under Article 66 of the proposed bill, we notice that the ground of marriage is no longer included. So if we're going to pursue that path, maybe we should also consider the other provisions on Book 2 to be accordingly amended. Thank you.
Thank you, Professor Neil. We note that and we'll make the necessary revision. Thank you. Yes,
One
sir.
more thing, under Article 66, under paragraph 4, there is a second sentence. A pardon shall in no case exempt the offender from the payment of civil indemnity imposed upon him or her by the sentence. I propose that a similar text should be included under paragraph 3 on amnesty, because under the law of amnesty and pardon, the person is not exempt both from the payment of civil indemnity based on People versus of the Philippines versus Patriarca.
Thank you very much, sir. We'll make that proposed revision. I will reflect that proposed revision. Any other comments? If there are none, okay. Any other comments to Article 66 on total extinction of criminal liability? If there are no further comments on Article 66, we can move to Article 67 on the prescription of crimes. Any comments on Article 67 on the prescription of crimes? If there are no comments on Article 67, we can leave this for now and go to Article 68 on the computation of prescription of crimes. Okay. If for now, yes, Professor Harvey.
On Article 68 po, if the body is amenable, right now it says that the interruption shall begin with the filing of the complaint with the appropriate government agency. So, kung pwede lang po natin i-reconsider and make it uniform that the interruption shall start with the filing of the information in court. Just to explain briefly, I think it's fair for the accused that the interruption of the prescriptive period is pegged at state action, meaning the prosecution has filed an information in court. Right now, what it does is it's interrupted as soon as the private offended party has filed a complaint with the prosecution service. So just to make it uniform and also fair on the part of the accused, may we put just filing of the information. Thank you po.
Thank you, Professor Harvey. Yes, maybe hear from you.
Your Honor, the prescription should stop when a complaint is filed before the prosecutor's office. Hindi naman kasi kasalanan ng minsan na delay doon sa prosecutor's office yung kaso. There was one decision na sinabi ng Supreme Court prescribed na yan. Pero on a later decision doon sa BIR case, sabi niya filing of complaint before the office of the prosecutors stops the running of the prescriptive period. And we want to maintain that, Your Honor. Kasi kung minsan there are stations wherein marami talaga silang docket, so we cannot fault them if medyo na-delay yung resolution. But just the same, the OJ naman is trying its best really to hasten the resolution of cases pending before our offices. Thank you very much.
Thank you, sir. Yes, ma'am.
Your Honor, I think there's a very recent jurisprudence, People versus Concebido, that's April 2, 2025, which reiterates that the filing of the complaint even before the prosecutor's office stops the toll.
Thank you, ma'am. So, we will... yes, Attorney Harvey.
Hindi ko po ini-insist. Pero just to explain, that Supreme Court decision is, again, interpreting the current wording of the revised penal code, which says complaint or information. And that is where the Supreme Court got its ruling. Complaint. The Article 91 of the RPC says complaint. But we are in the process of revising the law itself. So we are in a position also to override that if we want to. If we want to, again, if we want to. Just to further explain, yes, naintindihan po natin yung institutional realities, no? But coming from the perspective of the accused, hindi ko rin naman kasalanan. No? A prescription of the crime is, regardless of whether you did it or not, you're free. Even if it's murder, after 20 years, if the state is unable to prosecute you, wala na tayong magagawa doon. And that is the law's treatment on the accused, na at some point you're going to be free from the criminal process being over your head. So isn't it fair for that to be interrupted by a state action? After all, criminal law, criminal cases is between the state and the accused. You know, the offended party is on the background. Thank you.
Thank you. Thank you, Professor Harvey. So we, with all that's been said, we'll retain the provision as it's worded for now. For now. For now. Yes. Okay. We move to Article 69 under the chapter on partial extinction of criminal liability. Yes, ma'am.
Just a minor correction, Your Honor, in Article 67, so that we will be uniform with all the penalties or the nomenclature that we use. Instead of, this is, on the third paragraph, page 80, instead of using punish by restorative penalties, we will use light penalties po. Just to be consistent with the other nomenclatures of the penalty, Your Honor. Thank you, Your Honor.
Thank you very much. We'll make the revision. We'll reflect it accordingly. Any other? Yes, Professor Dan.
Madam Chair, I would like just to backtrack my apologies on total prescription, total extinction. It remove prescription of the penalty. That's the proposal of so the right of the state to execute the penalty will not prescribe, no? I'm just because in the previous Article 89 that's included, Madam Chair. So would the discharge from probation be also mode of totally extinguishing criminal liability? Yes, final discharge from probation. I think it's included in the law that once person is finally discharged, that will also extinguish criminal liability, Madam Chair. And I don't know for husbands, but the pardon extended by the wife in marital rape also extinguishes criminal liability. Should we include it here also? But I'm not really interested. But just for husbands, Madam Chair.
Thank you, Professor Dan. May we hear from DOJ?
Madam Chair, that provision regarding the pardon by a woman to the offended party, husband, is already deleted because of the subsequent provision under Book 2. We also already corrected this provision based on the consultation with different groups, especially the women's sector.
Thank you very much.
According to them, that is discriminatory against women.
Thank you very much, sir. Okay, so no further comments. If there are no further comments, we go to Article 69 under the chapter on partial extinction of criminal liability. Any comments on Article 69 on partial extinction of penalty? Yes, Professor Dan.
Yes, I read that this includes parole, which makes reference to the minimum sentence. It's precisely the indeterminate sentence law, Madam Chair. So I suggest we include either the indeterminate sentence or we adopt a determinate sentence, and then yes, subject to that deliberation on that, Madam Chair.
Thank you, Professor Dan. So we will reflect that accordingly, and we'd also ask for how it should be couched, or how you would like the revision to read. But okay, if there are no other comments on Article 69.
Your Honor, may we be recognized?
Yes, Dr. Tui.
Thank you. Thank you. On this point, from Professor Dan's comment, may we ask for to be enlightened on exactly what he means by the reference to ISL, or to make it determinate, and we'd like to understand better what we should comment on for this provision in relation to parole. Thank you. Thank you very much.
Thank you, Professor Dan.
Yes, I was discussing with the PAO earlier. This, of course, these are the positivist influence in the RPC, that we have the probation law, we have the indeterminate sentence. Supposedly, it's mandatory for judges to impose an indeterminate sentence consisting of a minimum term and a maximum term, so that after service of the minimum term, the convict may now apply for parole. Okay, so that's the indeterminate sentence. In contrast to that, we can adopt a determinate sentence wherein the court may impose just one penalty, which is a straight penalty, and then we just place a provision wherein one can apply for parole after serving 1/3 or 1/4 of that penalty, so that we remove the indeterminate sentence law already. That's up for discussion of the body and the House committee. Okay.
Thank you, Professor Dan. Dr. Tobia?
As a follow-up question, Your Honor, we'd like to know if the extent of the proposed revision, for especially on straight penalties, would apply to reclusion perpetua, for example, in life imprisonment, thereby changing existing laws on ISL, on qualifications for parole, and like more specifically the disqualifications. Would this apply, Professor Dan? Thank you, Madam Chair.
Professor Dan?
Yes. Okay, I discussed earlier regarding multiple or repeat offenders, because I think they would be up for or these persons may not be disqualified for parole anymore. That's also a valid question. What if a person is convicted of rape or terrorism? Should we disallow this person from applying for parole? Or it could be a higher threshold. 2/3 after it's found that he or she has reformed within the prison sentence, then after serving for 2/3 of that penalty,
Thank you very much, Professor Dan. Perhaps we could also ask the DOJ to weigh in on this, maybe if not now, then at another point in time. Yes, Dr. Tobia.
Last point on this provision, unless there are others who have comments. No, maybe I could seek some guidance from the chair and from our plenary, if this is a good time also to revisit Article 29 on the period of preventive imprisonment, and if preventive imprisonment would would fall under the list of uh, the things that would partially extinguish the penalty. And if so, if we're going back to Article 29, maybe this is also the moment to clarify whether or not this includes the time spent in police lockup, since we're trying to make a distinction already between preventive imprisonment in jail from time spent in police lockup. Thank you very much, Madam Chair.
Thank you, sir. May we? Well, we would be grateful for comments from the DOJ and from the body on for guidance also on whether or not the period of preventive imprisonment should be included in computing computing the period for serving out criminal liability, serving out sentence rather. For reference, Article 29 is in page 30 of the matrix. And we had a lengthy discussion also on what should be counted, what shouldn't be counted, when it should toll. But if the body would rather have this discussion at another, maybe after we complete book 1, we could also circle back to it then. For now, since we only have a few pages left in our matrix for completing book 1, I'm happy to also proceed and then solicit your comments later on if you need more time to mull this over. If there are no other... yes, Professor Neil.
Thank you, Your Honor. Just a minor observation. Under Article 69 of the bill, we replaced the term criminal liability with penalty. And for emphasis, instead of criminal liability is extinguished, the sentence is extinguished. So, to be more consistent with the tone of the rest of Chapter 2, since criminal liability and penalties carry different tone, maybe we could also revise the title accordingly, because it still reflects partial extinction of criminal liability here. And then also the entire title of Title 4 of extinction of criminal liability. Maybe we could also include the term and penalty or sentence, just to be more consistent with Chapter 2 of the bill. Thank you.
Thank you, Professor Neil. If DOJ has comments on this, we'd be grateful. Otherwise, we note your comment and we could revisit this at a later time. But thank you for pointing that out. So we should look into broadening the scope of Title 4, the description and extinction of criminal liability, also making reference to sentence. Article 70, we can move on to the discussion of Article 70 if there are no comments. Yes, sir.
Madam Chair, can we consider the dissolution, insolvency, or bankruptcy as a partial extinction of penalty with regard to juridical person?
Thank you, sir, for raising that. Thank you, sir, for raising that. We'd like to solicit comments from the body on whether or not, for purposes of course, it would make sense to factor that in with respect to partial extinction of penalty for juridical persons. We'd actually be grateful for language on what would constitute partial extinction of criminal liability for juridical persons. We can have the discussion if you're comfortable weighing in, if our experts are comfortable weighing in on that now. Otherwise, we can also discuss that at a later time once we have like a fuller grasp and a fuller set of penalties to mull over for juridical persons. Absent that language, perhaps it might we can proceed to discuss other articles as well if unless anybody would want to weigh in on partial extinction of liability for juridical persons. Yes, sir.
Madam Chair,
Yes, sir.
we're not keen on, we're not comfortable on adding bankruptcy as a mode of extinguishing, it's
Thank you, sir. Thank you. We note that. So bankruptcy and insolvency. And we note DOJ's opinion on that.
Madam Chair,
Yes.
how about the dissolution of juridical person?
Dissolution. Maybe hear from DOJ. Yeah.
Your
It's
Honor,
permanent.
please.
Yeah.
If I may
Yes.
answer. Because we are talking about the partial extinction of criminal liability. This is criminal liability and not the civil liability. So aside from dissolution, because the criminal liability may be imposed on the natural persons or individual persons of the corporation. So aside from it was mentioned earlier that we are opposed to including bankruptcy, insolvency. We're also opposed to including financial rehabilitation because we have the FRIA Act. So including the solution in the, as one of the instances for extinguishing or partially extinguishing criminal liability. Thank you.
Yep, Your Honor.
Thank you. Yes,
Good
Professor
afternoon.
Nico.
Yes. Your Honor, it might create an unfair treatment with respect to natural persons because even if they are insolvent, they are still required to pay the fine. And if they cannot pay the fine, they will be subjected to subsidiary imprisonment. So it might be there might be an imbalance here, Your Honor.
Thank you, Professor, for noting that. We'd also like to inquire, perhaps from DOJ and from the body, if we could have a similar concept of subsidiary liability, not necessarily tied to corporations or juridical persons tend to ring fence, and when they fall apart, there might still be other. If there are other jurisdictions that can also point to ways by which criminal liability could be exacted, we'd be grateful also for input on that and how subsidiary liability could also be made applicable if we were to consider that as well. Thank you. Thank you. If there are no further comments, we can move to Article 70 on the commutation of sentence. No comments to Article 70. We move to Article 71 on allowance for good conduct. Any comments? Yes, Professor Dan.
Yes. There's already provisions in Article 97 before for GCTA. And I think this has prisoners and accused are already entitled to this protection, legal protection, Madam Chair. Of course, I'd like to clarify why we are not incorporating the provision. I think it's good already, the previous Article 97.
Thank you. May we hear from DOJ? If we could inquire about the reason for the proposed change. I mean, why we chose to shorten or abbreviate what's now Article 71 as opposed to what Article 97 of the revised penal code provided for. Yes, yes, sir.
Madam Chair, I think the present Article 97 of the RPC has already been amended by the GCTA law under RA 10592. And that's why we refer this governed by this code and special laws. That's big reference to Republic of 10592 on the GCTA.
Thank you. Thank you, sir. Yes, ma'am.
Madam Chair, in addition to what Attorney Berlin said, by making this open to be governed by this code and special laws, it gives leeway to the Congress in case there will be amendments to the GCTA law in the future. Thank you, Madam Chair. So this is just for reference purposes.
Thank you, ma'am. Professor Dan?
Yes, there's RA 10592. The current wording actually in Article 97 already reflects what's in RA 10592, Madam Chair. So that's approved already by Congress. There are already vested rights over this. This was approved 2013 pa ho, no? And we're 2026. So if we remove this, we're basically we might be confusing a lot of individuals and lawyers and advocates po. So I just suggest we maintain the current wording, and then it will be up for Congress. Anyway, it will be subject to deliberations by Congress on how it will treat this GCTA. And if there's a proposal to remove or reduce the GCTA for which one is entitled to, it will be subject to the vested rights already of those persons from 2013 to 2026 po, Madam Chair. Just concerned it might be productive of confusion po. So since it has been approved by Congress, we retain it and then just up for discussion by Congress and the stakeholders po. Yes, thank you.
Thank you, Professor Dan. May we inquire with DOJ if they would be amenable to reflecting the amended Article 97 in place of the current Article 71 under House Bill 7142 and 7206.
It is sufficient, Your Honor, that it be referred to.
Oh, referred to. Yes. By this code and special laws.
Yes, Your Honor.
Or did you want us to spell out
I think the Republic Act and the official title of the lawyer.
Okay.
Thank you very much.
Thank you. Okay,
Madam
so,
Chair.
Yes, ma'am.
From the Public Attorney's Office. Well, based on what we have seen on the ground, sometimes the jail officers or those who would implement the, let's say, this GCTA would refer to the text of, let's say, the law. But if the original text of the RPC would take this out, it might be misinterpreted that this provision in the original Article 97 is changed if we only refer to it as in our revised draft na will be governed by RA number 10592. It might render it more tedious for the jail officers. Whereas, if we stay with the original text, hindi na nila kailangan mag-refer to a special law. Also, I believe that our goal for the RPC revisions now is to compile all rules so as to not belabor the readers from, oh, this is the new RPC. Oh, it referred to another RA. Let's check the RA. Let's just include everything here.
Thank you, ma'am. I agree with you. And I was wondering if DOJ would also consider, at least for now, looking, replacing the old or reflecting the old language in what's now Article 71 of the substitute bill. We can always go back to this, but until we are able to ensure that it is fleshed out as well, to save our implementers and students' time, we'd be grateful. But yes, sir.
Just clarification, Madam Chair. Is the Attorney Hernandez, are you saying that we copy verbatim the special law to the new revised penal code?
Isn't it is amended by RA 10592. Diba? Article 97 was amended by by RA number 10592. So let us reflect what is in the special law in our yes, not just the law title, but the same as how it is worded, like the full provision that we want to have to be implemented.
There's our consensus is there is really no harm in copying it to the new penal code, so it's okay.
Thank you. Thank you, sir.
The only
Yes.
problem is that there might be some administrative provisions there, insofar as the computations, etc.
Sir, if we look at the matrix, on page 82, we have Article 97 on the leftmost column, and then Article 71 of the substitute bill on the rightmost column. And if it will be possible to just transpose Article 97, since that already reflects the amended version of Article 97 as amended by RA 10592. Perhaps for now, we could use that as the placeholder instead of what's currently provided for in Article 71. So we just copy, sorry. We just copy that provision on allowance for good conduct. And at least for now, and then if that would address the concerns raised, we can always revisit this later on. But for our substitute version, just for the interest of our implementers also, we could just transpose that text. Sorry, to clarify also with our POW resource persons, would that suffice? Like, if you look at the Article 97 in the matrix, would that suffice for now, or did you envision having something longer than what's here?
It would suffice. Actually, it's just that my comment was we would prefer to have this detailed here as is than putting the general statement that it be governed by this code and other special laws. That's just a comment.
Understood.
Thank you po.
Thank you very much. So if if our resource persons in DOJ are amenable, we'll just we'll transpose it for now. And then move on to Article 72. I'm mindful of the time, and I'm very grateful for you all being here, and I'd like to maximize your stay.
No harm, no foul.
So thank you very much. So Article 72 on special time allowance for loyalty.
Your Honor, may I be recognized
Yes,
for
Dr. Tobia.
Article 71 before we move on to
Okay.
72?
Yes,
Very briefly, I have a proposition for the subcommittee, Your Honor. In debates during the technical working group between the Department of Justice and the DILG on the ramifications of the Ginto case, which modified the application of the GCTA provisions. No, the main result of that decision being all persons who are convicted will have no more disqualifications in relation to earning time allowances. And the issue that we had raised in the technical working group was whether or not
it is equitable to retain the disqualifications for persons who are not yet convicted. Meaning to say, they are presumed innocent, they're sitting in preventive imprisonment or remand detention, and yet, as persons who are presumed innocent, disqualifications apply to them. Whereas people who are already convicted, whether in truth they had committed these crimes or by legal fiction, they have no such disqualifications. And this issue could not be settled in the technical working group, and we'd like to bring this up to the subcommittee for their consideration, whether or not we should just remove all disqualifications to time allowances, given that convicted persons do not have any. Thank you very much, Madam Chair.
Thank you, Dr. Tabia. We'd like to solicit comments also from the rest of the body. If you have any, we'd be grateful if you could weigh in this. If there are no comments now, we can also circle back to this afterwards. Any comments on whether or not to remove disqualifications to time allowances? Yes, sir.
Yung sinasabi niya, yung nasa pre-trial stage, halimbawa na nakukulong, hindi sila, yung presumed to be innocent, hindi sila qualified. It's like this, Your Honor. If the person will be convicted during the sentencing, usually ang recommendation and the time that he spent under custody on those proceedings, i-credit dun sa kanyang sentence. And then, mag-a-apply sa kanya yung good time GCTA while he is serving the sentence. Ang qualification kasi ng law natin is that it can only apply kung meron ng sentensya yung tao. Now, halimbawa, sabihin natin, na-acquit. There's nothing to ano lang mangyayari doon sa time na spend niya na in custody siya, tapos na-acquit siya. Ang iba, sinasabi nilang, charge to experience daw. Ganun. Ang iba naman, may sa Board of Claims, pero merong qualification ng Board of Claims, you can only,
Yes, Madam Chair, if I may.
Yes, sir.
I think
Yes,
there are two kinds of conviction there. Acquittal, if it is beyond reasonable doubt, or if the accused did not commit the crime, you can avail of the, I think, 10,000, 20,000 pesos under the DOJ Board of Claims. 10,000, kala ko na amend. So, Madam Chair, tingin ko yun lang magiging recourse niya. Kung he was preventively imprisoned for a crime, then afterwards he was acquitted, he could claim against the government if the acquittal is based on the fact that he did not commit the crime. But if it is beyond reasonable doubt, the proof beyond reasonable doubt was not established, he could not claim the 10,000 pesos from DOJ. But I think that's the distinction, ma'am. I think the application of the law under Article 71 requires conviction. So you could only avail the GCTA law if there's a conviction. Otherwise, if he's still under trial, the benefits provided by law will not kick in. Thank you.
Thank you. Thank you so much, sir. Dr. Tabia, if that does that address your concern? If not yet, okay. Yes, Professor Harvey.
Yeah, just to support Mr. Tabia also, I think what we need to look at is if you're a person who's incarcerated and you are good while you're incarcerated, you should be rewarded for it regardless of whether you have final conviction by final judgment or not. That's what he's raising. If in the scenario na eventually na-acquit ka, di good for you. And we don't need to address the situation that he has to be given a certain benefit for the good conduct. What we need to address is the situation where you are eventually convicted. And while you are preventively imprisoned, you're good. You're good in the jail. You have that benefit. I guess what he is bringing up is, what's the substantial distinction between the two? Materially speaking, if you are a person detained, deprived of liberty, regardless if there's a conviction by final judgment, you are deprived of liberty. So you should be entitled for the things that are beneficial to you. Thank you.
Thank you, Professor Harvey. Yes, ma'am.
Madam Chair, we agree with Dr. Tobia and Attorney Harvey that GCTA should apply even prior to conviction, especially that the trial stages of our courts at times, not always, with due respect to the courts, it, it it takes time for trial to finish, and there are times that during trial, not all accused are on bail. So we hope that this body could consider that GCTA should apply at all stages of detention, especially from arrest or PNP custodial detention and similar situations. Thank you.
Thank you. Thank you, ma'am. Yes, Professor Dan.
I think that's already included in the current provision in Article 97, Madam Chair. Because it says here, the good conduct of any offender qualified for credit for preventive imprisonment, which are the detention prisoners, and then those convicted. Subsequently, they can earn GCTAs already, Madam Chair. So that's why I was suggesting we adopt. This is the actual provision in RA 10592, which was already included in Article 97. And I think it's also quite clear in Article 29 that aside from the GCTA earned from preventive imprisonment, the period of preventive imprisonment shall be deducted from the sentence consisting of deprivation of liberty if the person is convicted subsequently by the trial court and by the courts. So double benefit for the offender under Article 97 GCTA, and then Article 29, the period of preventive imprisonment. In fact, it says here, I don't know if that's the, it says here, my understanding is full credit for the entire preventive imprisonment. It does not distinguish anymore whether the PDL actually followed the prison rules or regulations. It has no qualifier, Madam Chair. I think there's full credit for the entire preventive imprisonment. And on top of that, Article 97 grants also GCTA for the period when one is under preventive imprisonment. I think it's very clear. Probably the problem is in the implementation by the jail authorities, no? The correctional facilities, Madam Chair.
Thank you, Professor Dan. Yes, TOJ.
Madam Chair, honestly, I don't know where the confusion is coming from, in the sense that in the ground, the jail officers or the corrections officer compute the GCTA so generously. In my hand right now is a certification from a jail in Cebu, and the actual time served of the convicted person is only 6 years and 1 month as of February 11, 2024. However, considering all the detentions in the police station, in the BJMP, the CPDRC, plus the GCTA credits, the overall total of his GCTA is 14 years, 8 months, and 28 days. So he earned a total of 14 years, 8 months, and 28 days, despite the fact that he only served 6 years and 1 month. So in the computation of the GCTA, in actuality, it's very generous. So this is the case that I mentioned to you, that I was surprised that the accused who was convicted of homicide was already outside drinking Starbucks. So I'm not sure, and as Professor Dan mentioned, preventive imprisonment is actually included in the computation of the GCTA. Madam Chair, thank you.
Thank you, ma'am. Yes, Dr. Tavia.
Thank you, Madam Chair.
to address the comments so far, no, I think one thing should guide our progress on revising these provisions, no, and that is to keep it simple. And I think when we go over the wording right now of Article 71, what I see is qualifications. There's a qualification for people to earn good conduct time allowance as long as they're qualified for credit for preventive imprisonment. So if the intention really was we give everyone credit for preventive imprisonment, and therefore we give everyone credit for good time for allowance for good conduct, then it should say explicitly that this is our intention. So let's just keep it very simple. I do understand that we can infer this from other provisions mentioned by Professor Dan. So I suggest that we just consolidate it in a simply worded provision. On the matter of what actually takes place on the ground, no, I think in many places there is an effort to be generous in the way that they implement the granting of credits for both CPI and all the kinds of time allowances that are available. I will say though that a lot of this is based on the discretion of officers on the ground, because they understand that there are disqualifications in the law. So they have to make choices on whether or not to apply generously the grant of these allowances or not. So maybe in this one example from the prosecution, talking about a case in Cebu, to me, this is not unusual. We see this all the time in jails all over the country where they apply it liberally and very generously. But at the same time, in many jails that I visit all over the country, many officers are petrified to make such like generous applications of the granting of allowances, because they don't know whether or not they will be held administratively liable for applying it so liberally. So one thing that could really help the frontline officers in detention facilities is to keep the rule very simple. In this case, I think we're considering a proposal where we will just give everyone CPI and therefore give everyone all the allowances for good conduct. I think that would help our frontline officers very much. Thank you, Madam Chair.
Thank you, Dr. Tuvia. Yes, Professor Dan.
Yes, actually before only convicts by final judgment are entitled to GCTA, right? And the GCTA law is quite generous. It provided also for detention prisoners, no? But I understand the comment that there's a term qualified, no, for preventive imprisonment. For those convicted already by final judgment, there's no disqualification, no? But there's a qualifier for those under preventive imprisonment who are not really yet guilty, probably, if I understand correctly. So probably the proposal is the good conduct of any offender under preventive imprisonment. There's no qualifier anymore. Under preventive imprisonment, and those convicted prisoner, there's no qualifier anymore of qualified for preventive imprisonment. I think that would be good, because even those convicted already by final judgment are entitled to GCTA. And we're talking here of individuals who have not yet been convicted, no? I think I agree with that proposal, Madam Chair.
Thank you, Professor Dan. Yes, sir.
I understand the comments. I understand the side of Attorney Bilang and Professor Kalika. Really, these are generous things. Magandang patas yun ito kasi nakakatulong din sa mga ano. But we are trying to craft the new code in parang balancing tayo. It's a balancing act. Try to think also from the point of the offended party. Ang hirap i-explain na bakit yung pumatay sa tatay niya, sa anak niya, nandyan na sa labas. That's why we're trying to craft this na from the point of the accused, kasi restorative, reformative. But let us also take the context of the offended party. Madali lang magsabi na hindi yan beneficial sa accused. Bakit beneficial ba siya sa offended party? Halimbawa, yung kamag-anak mo ang pinatay, maiisip mo ba ito? Even myself, God forbid, a member of my family be subjected to these crimes. Makalimutan ko ito lahat siguro na sinabi ko because I wanted that person to really suffer. So, it's a balancing act. Yun lang sa akin, if we craft a new law, if we craft a new penal code, let us balance it with the rights of the accused and also the rights of the offended parties. Tsaka let's make it simple enough. That's what we are trying to do. We make it simple enough for us to prosecute. Anyway, available man yun sa defense kung ano yung defense nila. Let's not complicate things. That's what we are trying to do dito. Thank you po.
Thank you very much, sir. Okay, we note everybody's concerns. We can always go back to this. For now, the provision, we will still keep to our previous agreement to reflect Article 97, Article 97 as amended in Article 71. Now we go to Article 72, Special Time Allowance for Loyalty. Are there other comments? If there are no comments to Article 72, can we move to, can we briefly tackle civil liability? That's Article 73. If anybody has comments actually on the chapter of persons civilly liable for crimes, we'd be grateful to solicit those until, I'm mindful of the time, it's almost 2 o'clock, but I would be grateful if we could still try to cover as much as we can until 2. Yes, Professor Harvey.
Yeah, civil liability, Article 74. There's a proposed addition all the way down. I think this is 5th subparagraph. I'm referring to the paragraph that says, likewise, the civil law shall also govern the civil liability of a minor over 15 but under 18 years of age who acted with discernment. I suggest that this be made standalone, separate from this provision. The rest of the provisions deal with instances where there's no criminal liability because there's a justifying circumstance or an exempting circumstance. That particular paragraph I just read deals with something different because there is criminal liability. This is a minor who acted with discernment. So I think this should be the new Article 74, and then this proposed Article 74 becomes 75 and so on. Thank you.
Thank you, Professor Harvey. We note that proposal. Other comments to Article 73, 74? Let's stick to 73 and 74 first. If there are no comments, no other comments to these, we can always revisit this later on. Article 75 on subsidiary liability, civil liability. We can always go back to this also.
Madam
Yes,
Chair, if I
yes,
may,
ma'am.
we would just like to correct some Article 72 because this is we just copied the revisions under the GCTA law or RA 10592. So, in the first part, instead of a deduction of 3/5 of the remaining period of the sentence, it should be 1/5 only. And then, and on the part that On this part, it says a deduction of 4/5 of the remaining period of the sentence shall be granted in case of said prisoner chose to stay in the place. This should be 2/5 instead of 4/5. So I think there is just a typo error po. Thank you, Madam Chair.
Thank you, ma'am. We will reflect those revisions as well. Yes, Professor Neil.
Thank you, Your Honor. Just a quick input. Since we're at Article 72 of the proposed bill, maybe there are other also provisions in the proposed bill which contains the word prisoner. Maybe we could dispense with the term prisoner and replace it with person deprived of liberty to be more socially acceptable, or any synonymous words that will be socially acceptable. Thank you.
Thank you, Professor Neil. We'd like to consult DOJ if we could make that revision, global revision to prisoner. We will replace it with PDL. Thank you. Thank you very much. Okay, so we'll reflect that global revision for now. Other comments on Articles 72, 73, 74? If there are none, so Article 72 will be amended accordingly, and then also the global reference to prisoner. Article 73, no further comments for now. Article 74, we note the proposal to carve out that portion on civil liability of a CICL who acted with discernment, and create a new section. Other proposed revisions or comments? If there are none, Article 75, are there comments to Article 75? If there are none, Article 76 on subsidiary civil liability of other persons. And then if there are no comments for this, we can move also to Chapter 2 on what civil liability includes, and then perhaps also look into expanding this chapter to provide for civil liability for juridical persons as well. And then again, we'd be grateful for proposed language for this. It's 1:56. I'm very grateful for what's been contributed so far. I'm very grateful also for your time and for the way you constantly extend yourselves and share your expertise. Thank you so much. Last call for any proposed comments, revisions on Article 7 on civil liability. If there are none for now, we can go back to this next meeting. And then I'd also like to ask if you have comments also on the extinction and survival of civil liability. That's Chapter 3. So that's Articles 85 and 86. If there are no comments, we can always go back to this. So it's 1:56. I'm so grateful. Yes, Professor Dan.
Just,
Thank you.
just
Thank you.
one last,
Thank you.
which is, I think, will be appreciated by the PAO. Article 99 was removed in the draft on who gives the GCTA, Madam Chair. So I think this is a very important provision because, of course, it's given by law, GCTA, then who should give it? The parole will be granted by the Board of Pardons and Parole. The probation law will be granted by the court. So there are specific persons who can grant parole and then probation. There's also a specific provision on GCTA, Madam Chair. That's Article 99. Just so we can actually fully implement the GCTA, because there might be a provision for GCTA, but it cannot be availed of because there's no one mentioned as the authority to grant GCTA, Madam Chair. That's included in the previous RPC, that's Article 99. So if, okay, since we're retaining Article 97, you just also retain it, Madam Chair, then subject it to discussion by the House po. That's okay with the DOJ po.
Thank you, Professor Dan. Thank you for raising this. Yes, sir.
Yes, Madam Chair. I think the reason behind the deletion of Article 99, because there's a specific provision under RA 10592, I think that's Section 1, Rule 7, which provides who are authorized to grant allowances. So anyway, there's no harm if we will reproduce this, just like Article 97, if we will do that.
Thank you very much, sir. So we will reflect or we will reproduce the text of the amended Article 99 in the substitute version for now. Yes, sir.
Madam Chair, final, I think with respect to Article, 74, the last, haba pa. Hindi lang, Madam Chair, will count the paragraph 1, 2, 3. The third paragraph, capitalized paragraph under Article 74. The civil liability for crimes committed by a child above 15 but under 18 years of age who acted without discernment. I think that's the normal, the normal rule, no? It should be limited to those minor who acted without discernment. But we have to consider also there is a old Supreme Court decision which I think is still active, the case of Salen versus Balsi, a 1960 decision. According to them, according to Supreme Court, there is a gap, no? By which a parent may be civilly liable for the crime committed by his minor son, even if he acted with discernment. This relates to quasi-delict. At that provision, the Supreme Court used 2180 in relation to Article 2176. According to Supreme Court, this is also a gap which will also make the parents civilly liable for the crime committed by his minor child. We have to consider. So I believe whether he acted or without, with discernment or without, the parent may be held secondarily liable for this act of his minor child. That is for consideration of the body, Your Honor.
Thank you, sir. We note that. Just to clarify that, if you could also tell us where to insert or if the text doesn't address what you proposed, we'd be grateful for language to be inserted to properly address it as well.
Madam Chair, if we will abide by the decision, although it's an old decision, there will be no distinction whether the minor acted with discernment or not. His parents will be secondarily liable for the act committed by. But as long as the requirements that the child is living with the parents and the parent exercise due diligence or good father for family in order to be not civilly liable for the crime committed by his minor child.
Thank you, sir. So we will add with, so to clarify, we'll insert with before without, so that it will read civil liability for crimes committed by a child above 15 but under 18 years of age rather, who acted with or without discernment. Yes, Professor Dan.
With due respect, would that be covered by the general rule? Every person criminally liable is also civilly liable, because the minor who acts with discernment will now be criminally liable, right? So he or she will be covered by that provision that a person criminally liable is also civilly liable. Would that be sufficient for that purpose?
Sir, yes, sir.
Yes, Madam Chair, I think the situation envisioned here is that the child, this will only kick in if the child's property is not sufficient to satisfy the civil liability, and the property or the secondary liability of the parents will kick in once the child who committed the crime did not have no sufficient property. This is a secondary liability. Yes.
Thank you, sir. Thank you. Okay. Attorney. Attorney.
Ay, ma'am.
Ay, sorry,
Yeah, Madam Chair,
yes,
very
Professor
minor
Hardy,
lang po.
sorry.
Yung situation po na gustong i-address ni Attorney Berba, and yung two sub-paragraphs after po, yun po yung kung saan ako nag-comment kanina. Yan, for those who have acted with discernment. Bale, Madam Chair, if the body wants to adopt with or without discernment, then remove na po yung comment ko kanina to carve it out as a separate provision.
Thank you. Thank you, Professor Harvey. Okay. It's past 2. Thank you very much for the time that you spent. We're so grateful. For the next TWG, we do not have dates yet, I think. Okay. We will tentatively schedule the next TWG after April 8th. Cognizant also of our resource persons' schedule constraints. We will just announce it in our chat group. Thank you very much for your time and your expertise. We're so grateful to have covered ground, and we look forward to hearing more and also receiving the proposed language also and position papers that you could also share with us. Thank you. This subcommittee meeting is suspended.